here, and I've got Hubs Steve here with me, and I'm gonna text Ship now. He is um, in the car, but he was gonna be getting to a place where he could join us not too long after we started. So let me text him here and say we have started. Join when you can. All right, and then we'll get started. Hold on a second.
Based on Ship's last post, it looked like he was driving to the nearest igloo.
Yeah, he was uh doing a thing over the weekend, and he bugged out a day early because that snowstorm was coming, and now he's going back to where his home is with his family, and they got a ton of snow. So let's see. Okay, here we go. All right, so I'm sure he'll join up when he can. All right, so what we're going to talk about tonight is basically where do things stand in the various appellate cases, and including how many, don't even sure I know how many there are, at least five, right? That affect, they're either directly Trump's cases or affect Trump in some way or another. And that's not counting the ones that he has that aren't in the Court of Appeals yet. So, but tonight I think we're going to just focus on the cases that are actually in the courts of appeals, but we will talk about it. The question just came in. We are going to talk about kind of how that the timing will work, how the appeals cases will affect the other cases, which are still in the trial courts and still ongoing, one of which is in New York, one of which is in Georgia, um, and one of which is in Florida in the federal court. So, okay. King, let me ask you, did you watch the rest of that testimony this week in Georgia?
I watched every minute. It was enthralling. Yes.
I thought maybe you did. So you can give us an update on that because I didn't have time to actually watch the testimony, but I was keeping track of it.
Uh,
Okay,
what
so go ahead.
update is there were no more witnesses. Uh, the last witness who testified was Attorney Bradley, who used to be Nathan Wade's law partner, fraternity brother, and first lawyer in Wade's divorce case.
And
Uh,
sad puppy witness.
and he was somebody got to him. It looked like.
Well, one of the questions, since you mentioned him, I'll ask you now. One of the questions we got was on that case is apparently there was a waiter who said he served both Bradley's lawyer and Wade in a restaurant. Was this testimony, or was this just stuff that was coming up in the
Yeah,
public discourse?
this was a waiter that reached out to somebody, either somebody online or somebody in a lawyer in the case. But the waiter, when he saw the same testimony I saw of Mr. Bradley, uh, I guess his antenna went up, and
Mm.
he reached out and said, "Hey, I saw those two dudes together eating dinner, and I waited on them." And they were in a deep discussion through the whole thing.
Okay,
He did
but
not
this was
say.
during the trial. Did he say when it was, or
Yeah, he said it
the
was
hearing?
about 4 or 5 weeks ago.
Okay.
Okay, now that timing is significant in this sense. The text messages that Ashley Merchant had with Bradley started last September.
Okay, and to
It
remind
went
everyone, Miss Merchant is the lawyer for the co-defendant with Donald Trump, who is bringing the disqualification motion.
and she had very frank and enlightening uh, text discussions with Bradley, in which she asked Bradley straight up, "Did this affair begin uh, before Nathan got hired by Miss Willis?" And the answer was absolutely. No qualifications. No. totally different from the way he put it on the stand. The way he put it on the stand is, I don't really remember. I'm speculating.
Right.
He didn't say that to her in the text. He and it and after a sequence of text messages along those lines, in which he volunteered his knowledge of when it began, she wrote up the motion that was filed early in January to disqualify Fani Willis and Nathan
So,
Wade.
pro tip, if you're talking to a lawyer, anything that you tell them could potentially end up in a pleading that they will file with the court. So,
And, and,
be
and
advised.
well, she actually drafted the pleading
Right?
and put what he told her in the text in the pleading,
Right, of course.
and basically told her, he's a lawyer, she's a lawyer. He knows what that pleading is, what she intends to do with it, and she emails it to him and asks, "Is this okay?" And he wrote back and said, "Yes, it's fine.
And that's good
Go
practice,
go
people.
get him.
Right. Yeah,
Yeah,
okay. That's good
go get him.
practice.
You're a great lawyer. Go get
Right. That's good practice. You when the witness tells you XYZ and then you put that in your pleading because that's your good faith
him."
basis for asking the court to do something for you. It's a good practice to go back to the witness and say, okay, this is what I wrote up, what you said. Do you have any issues with that? Or if I got it wrong or right or whatever? It protects her. She can't be accused of making it up. Right. So,
Yeah, and so those texts ended when she filed the motion,
of course. Right. Because he
and
realized he should have kept his mouth shut.
he should have. But
Oh.
and so that brings us to the waiter. And if the timing goes like this, she filed the motion. It's about to blow up the prosecution in the Trump case, uh, and then Wade and uh, Bradley meet over dinner and have a serious, long, over the dinner conversation, and then both of them testify. Both of them, when asked, "When's the last time you two talked?" They said about 2 years ago.
Aha. Okay. So this waiter came forward. He said he saw Wade and Bradley, or Wade and Bradley's lawyer, because that would make it
Wade,
different.
he said Wade and Bradley,
Bradley, the lawyer. Okay.
the lawyer.
All right.
So
Right.
if that's the timing, if he saw them before they both denied talking to each other, and after Bradley was very frank and forthcoming in his text exchange with Miss Merchant, that smells like uh, Wade said something to make him clam up.
Right. All right. So this waiter comes forward but he didn't testify. Did they ask the judge if he could or what?
No, nobody's done that yet
So far, okay.
so
Well,
far.
that might be coming. All right. So we got one question that was specific like that, and I hadn't understood what was going on with this waiter. So maybe that waiter will testify. Maybe he won't. The judge probably won't let him because the judge will probably conclude that they don't need that in order for him to rule on it. Is my guess. But thank you for asking, the person who asked that. And it is indicative of, in a big case like this, witnesses just sometimes appear out of the woodwork. I mean, you saw that with the O.J. Simpson case. We saw that with Justice Kavanaugh's confirmation. Right? People are watching on television, and then people who know the participants or have interacted with them come forward, and that doesn't happen in your garden variety case. Okay, so I wanted to start tonight with, and we'll come back to the Georgia case. I've got it on my list, but since you confirmed you saw it, I wondered if you could tell us, King, whether this waiter testified or not. But what I wanted to start with is a new development tonight, which has to do with the former president's case that's currently in the Supreme Court, that has to do with the Colorado ballot, him being kicked off the ballot in Colorado, purportedly under the 14th Amendment. So, Margot and King, have either of you seen the latest on this tonight?
I have not.
Okay.
And
So,
Yeah,
and
yeah.
maybe you guys can remind me, what was the one that the Supreme Court already took up. Was that Colorado?
Yeah, yes, it's
Okay.
Colorado.
Yeah,
Yeah.
it's been briefed. It's now submitted to the court. Colorado is one of the Super Tuesday states, I believe, which is
Yes,
this
which is
Tuesday.
which is in
Uh,
2 days, right?
Even though that order by the Secretary of State taking him off the ballot is stayed, um, the court probably, I would guess, the court had a internal clock to try to get that opinion out before Tuesday.
Yes, I think so too. And it appears that that is what they're going to do, because the latest and greatest is that the Supreme Court has updated its website to say that on Monday, the court may be issuing decisions, right? So the court's calendar shows pretty much what they're doing every day. And they never 100% completely pin themselves down on something like this that doesn't say, we're definitely issuing an opinion on Monday. But when they announce, they change their website to say, well, the court may issue opinions on Monday, it basically means they're going to. And they do that for the benefit of the public and the media, so that the media can, who are the interested, folks, can be prepared to say, hey, there's an opinion coming out on Monday. So my guess is that this Colorado case is getting decided today or tomorrow and issued tomorrow. And even though, King, you're right, the Colorado Supreme Court stayed taking Trump off the ballot, meaning that he was still technically and literally on the ballot. But I still think that the Supremes, they took this case and expedited it. It was a very short briefing on it. And it seemed to look to me like they had planned all along, if they could, to rule on it before the voting, so that the voters in Colorado can know when they go into the ballot box, or uh, behind the curtain, as we used to do with the old machines, that whether he's a viable candidate or not. Like, the public's entitled to know this, even though technically he still is on the ballot. But if there's still a cloud hanging over him that he could be thrown off, that's not great, especially if they're going to turn around in 2 months and say, we're not throwing him off, right, or whatever. So I think this is a good thing that this is coming out tomorrow in advance of the voting. But the usual suspects, Margot, are losing their minds on the left on Twitter, saying that this is judicial intervention on behalf on behalf of Trump. So okay.
Along those lines, Leslie, something I had kind of tweeted out the other day was how infuriating it must be for the justices. These are lawyers at the pinnacle of their career, and they're wasting all of this time because Trump derangement syndrome has just infiltrated the country.
I know, it's taken
That
over
they
half of our profession, unfortunately.
Right, and they're having to deal with these cases because from a constitutional structural perspective, it is destructive if they allow these kind of things to go on. Usually the Supreme Court can let kind of injustices happen for quite some time to let the law develop, etc., before they come in. But this is a different character.
I
And
agree. It's a horse of a different color. And I tweeted that out tonight, that the Supremes care about the franchise, right?
right.
It's not enough for the Colorado voters to know, well, that might get undone later. They care about these people who are going to vote on Tuesday.
Yep.
So, yeah, I agree with you. And that raises an interesting question about the timing of the immunity case, too, which is really what we wanted to talk about tonight and what we're going to turn to next. So, we'll come back to that, because I think my own personal view is I think the Supremes are looking at these cases the same way, in terms of timing, but we'll get to that. Okay, so now, so primarily what we want to talk about tonight is the immunity case. So, this is the DC federal prosecution by the special prosecutor Jack Smith, and he, as we all know, indicted the former president back in August of last year, and the president asserted that he has presidential immunity. And that case, the trial judge, Judge Chutkan, said, no, you don't. And the DC Circuit recently, on a fast track, ruled that they agreed with her that Trump does not have immunity for criminal prosecution for official acts, for acts that he engaged in while he was president that are presidential, duties, presidential conduct, etc. And because the Court of Appeals had said that they were going to, on a fast track, send the case back to the trial judge, Trump's lawyers had asked the Supreme Court to stay the case further until they could brief the issue to the Supremes. And, a bunch of the liberal commentators said, oh, they're not going to take that case. And Ship and King and I had all, Steve too, we'd all said, no, the Supremes are definitely going to take this case because it's of such high constitutional importance. And as we were just saying, the Supremes, I think, actually do care, all of them, left and right, about the franchise, about your right to vote. So they definitely were going to take this case and decide it. So the prosecutor had asked the Supreme Court in December to skip the Court of Appeals because they said it was terribly, terribly important that the Supreme Court was the only one who could have the last word on this, and they wanted it decided right away. And so they asked the Supreme Court to take it away from the Court of Appeals, and the Supremes didn't do that. They said, no, we'll let the circuit rule on it. So now the circuit has ruled on it, and Trump's lawyers have asked for a stay of the trial pending the Supreme Court's decision. And the prosecutors opposed the stay, saying that, that wasn't necessary. But they asked the Supreme Court to consider Trump's request for a stay as the actual petition to be heard, which would have followed. Normally, you have 90 days to file your cert petition. And Trump was asking basically for the normal amount of time and also for the case not to be sent back to the trial court. So the special prosecutor asked the Supreme Court to consider the request for the stay as the actual pleading, and the Supremes did agree to do that. They set a schedule, and they have set the argument for this case on the immunity for the week of April 22nd is when it will be heard, which means that they will almost certainly decide the case by the end of the term, which ends at the end of June. Now, even as much as a few years ago, you could say for sure that the Supremes would issue all of their opinions by June 30th. But since the pandemic has come along, they sometimes have slipped over into the first week of July. I don't know whether they will continue to do that or not. But basically, I think it's almost for sure that they will decide the immunities case before the end of the term. So the last week of June or the first week of July is probably the latest that it will come out. So, um, Margot, had you had an opinion about whether or not you would, that you thought they would take this case and what they will do with it? Because the rest of us have discussed it ad nauseum, but I'm not sure if the folks listening know what your view is.
Sure. So I had thought that they would take it. And what my kind of gut now is they're going to be looking at immunity, as I think you noted in maybe your post about this. It's whether and how much immunity there is. And
Right.
I think that's something that especially the press that's pushing anything anti-Trump is trying to do, is to make it look like the only issue is, can he, while president, shoot somebody on Fifth Avenue in New York and be prosecuted?
Right.
When really there are
That's
some
not
very
the issue, right,
right,
at all.
though
Yeah.
that's not the issue, and there are some very close questions and difficult questions. And what I think the court's going to be looking at is, in this indictment, what in there is purely a presidential duty, and can you put that in an indictment and let the jury hear about it? Or does presidential immunity keep that out? So, my take is that it's going to really screw up the indictment because Smith, by nature, had to put in a lot of stuff that was completely within Trump's presidential authority in order to kind of build up this idea that he did something criminal. And from my perspective, I don't see how the president does not have immunity on those things. And I think that it would be inappropriate for the grand jury to include that as part of the indictment. So I could very much see the indictment being thrown out and the definition of, or some parameters on immunity set, and that consequently it's going to mean the trial can't go forward.
I've got a different view.
Okay, so let's stop here for a second. So we're going to get to the question of if they decide there is immunity, if they decide, right, well, kind of either way, then what happens, right? Especially if they decide that it turns on whether the acts are official or not official. So if the Supreme Court says there's no presidential immunity, then that's the end of it, right? There's nobody to appeal from after that. The case will go back to Judge Chutkan and there will be trial on the current standing indictment. Subject to other problems that the government has with those counts, including that the Supremes also have on their docket and will hear argument the week before this argument on whether the obstruction of justice statute that all these J6 people have been indicted on and Trump is indicted on, whether that's a viable theory that the government is using or not. But subject to that, those kinds of problems, if the Supremes say there's no immunity, the case will go back down for trial. But even if the Supremes do say there is immunity, then the question is going to be, as Margot's been explaining, for what? For what kind of acts, right? Now, Trump's lawyers in the Court of Appeals, in the circuit court, they conceded that the president could be prosecuted for private or purely personal acts. So, like, yeah, the example they always give about if he shoots someone on Fifth Avenue, could he be prosecuted for that? I think the answer is yes. I think everyone thinks the answer to that is yes, right? If he shoots his wife or his dog or the Secret Service agent or the Secretary of State, or, if he does something while he's president that is personally and it's a crime, I don't think there's any real argument that he can't be prosecuted for that. So the question is not that at all. And the Supremes, Margot, as you said, correctly framed the issue. They wanted to know whether and to what extent there is immunity for the President of the United States for acts that are allegedly official acts. Now, that's not the way that the liberals want to frame it, right? They want to frame it that the can't be true that the president can get away with violating the law, right? The president can't have a get out of jail free card for any and all criminal violations, and that's just not the issue at all. So let's stick first with the first question, which is the way the Supremes have framed it, which is whether or not there is any immunity for official acts for the president. And just so folks know, the Supremes have already decided in 1982 that the president is absolutely immune for civil lawsuits for his official acts. So the president in that case was Nixon. The case is in 1982 because even though Nixon wasn't president by then, a civil servant had sued Nixon for being fired. He claimed he was a whistleblower and he sued Nixon. His name was Fitzgerald, so the name of the case is Nixon v. Fitzgerald. And it rumbled along in the courts until 1982, the Supremes decided it. And they said 5-4 that the president does have absolute immunity in civil cases from lawsuits. Now, interestingly, the 5-4 is an interesting aspect of it too. And I want Steve to tell us a little bit about that case, but just so we're all sure what we're talking about. So that has already been decided. So the only thing that's up for grabs in this case is whether or not basically that same rule is going to apply on the criminal side of the courthouse. And again, only for official acts. And then we're going to get later to, well, what does official acts mean? How far does that go? But for starters, let's focus for a minute on this case that is already the law and has been since 1982 about the scope of the president's immunity. So Steve's going to tell us what the Supremes decided in that case and kind of what the arguments were.
The issue in that case was the extent of the immunity that the president has. No one claimed that the president didn't have some level of immunity, and the entire dispute was over whether it was qualified immunity or absolute immunity. And the Supreme Court, as Leslie said, decided 5-4 that it's absolute. In other words, if the allegation, if the claim involves an official act of the president, he's immune, no more discussion. Had it been, the dissenter said it should have been qualified immunity, where you would get immunity, but only if the president believed, and his belief was reasonable, that his acts were lawful.
So qualified immunity is the kind of immunity that police officers get and other government officials get. They are immune, but the act in question has to be within the scope of their responsibilities, and there has to be this extra component of, do they reasonably and actually believe that what they were doing was basically fell within the scope of their job. So absolute immunity, you would not do the inquiry about good faith or objective reasonableness. You would only look at whether things are official acts or are not official acts. So there's been, a few cases that have rumbled along in the courts the last few years about whether President Trump had immunity for like subpoenas and to give up records and other things. But this old case, relatively old, 1982, is the only law I think that exists other than the recent opinion issued by the District of Columbia Circuit in this case on this question of the president's actual immunity for his official acts. So I wasn't surprised to see the way they framed the question of whether that immunity exists and what is the extent of it, because that was basically the issue in Nixon v. Fitzgerald, except on the civil side. It looks very, very similar. So I think that's largely what the Supremes are going to want to hear about. So, King, let me turn to you then. You said you had a different take.
Yeah,
Margot seems, yeah. Let me say, Margot seems to think that they will say there is immunity. Did I hear that right, Margot?
Yes, I do
Yeah,
think they will say there is immunity.
yeah.
I,
I think so as well. King, what's your
I,
view?
I agree with that, but how they get there, I think I see it. I see it differently.
Okay.
I do not think this court wants to hear the facts of the Trump case. Does
Right.
not want to get into the weeds of this particular indictment. The question was posed very, very broadly, about as broadly as you can. And they want to know, is there presidential immunity for an indictment that uh, involves, they use the word involves, uh, official acts. There's no mention in there of this particular indictment, no mention of Trump, no mention of any of the statutes that he's charged with violating. It's a very big picture approach that they intend to take. I think if they have to get approval of what, five justices to pose a question like that.
Well, they only
And
needed 4 to take the case.
take the case, but to pose
Right.
the question, to actually to direct the parties to address a single issue, which is what they
Right.
did.
Right.
Don't they need five? I'm
They
not sure,
might. They might. I'm not sure on that either. We'll
but
check on that. Yeah.
four or five, they whatever it is, they 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 carefully crafted the question to avoid getting into the weeds of what we've heard from both sides on the Trump case.
So,
Trump, because Trump has two hats. He's wearing the hat of a candidate, and at the same time wearing his president's hat. And it's difficult to dissect that. And I don't think the Supreme Court, wants to get bogged down into that. They want a high level discussion of whether there is absolute immunity, period, for any president.
Right, I
so,
agree. It's
so,
it's written as a very conceptual question. So let me read it to you, and then Margot, I'll let you chime in.
sure.
So this is literally what they told the parties they wanted them to discuss. Whether and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? Now, Ship, I think, thinks that this issue of who's alleging that it's official acts and that's caught my attention too when I read it. Do they mean as alleged in the indictment? Do they mean alleged by the prosecutor or alleged by the defense? So when he finally joins us, I want to have a discussion with you guys about that. But Margot, give us your response to what King's been saying and this formulation by the Supremes.
Sure. So I absolutely agree that they're going to be focused broadly on it. And the question I have then is, will they remand it for the lower court to decide where it that immunity fits in what the prosecution is? Or will they say the indictment clearly crosses this line in some parts and it has to go?
Right. All right. So let me stop you there because I want to have that discussion. You guys keep wanting to go to the next question, and I really would like to have Ship on the line for that if we can. But let's start with the first part of the question and then debate that. We all, I think, are in agreement that the Supremes are going to find that there is immunity, but that's not written in stone anywhere. There are plenty of lawyers on the internet and on TV saying that they think that the Supremes are definitely not going to say that the president is immune, that there is any presidential immunity for prosecution criminally for official acts. Now, I don't agree with that, but so that people can understand what the issues are. What are the questions there? Margot, why do you think they're going to conclude that there is immunity?
From a structural perspective, the president, being the commander in chief, cannot have to worry about being charged by a state prosecutor or a federal prosecutor for something he did as commander in chief, which could include ordering the bombing and an American citizen is killed. I just think of kind of the worst case scenario, and that can't possibly be squared with what our Constitution allows to happen.
Right. I have a similar view. King, what's your view?
I start with Nixon versus Fitzgerald, which held back in 1982 that the president is absolutely immune from civil suits for for his conduct involving official acts. The issue here is, does that extend to criminal prosecutions? In Fitzgerald, Nixon was long out of office when he was brought into the suit. He had admitted that he had orchestrated the firing of Mr. Fitzgerald. He admitted publicly. Uh, the issue there was uh, the Nixon side said he was let go because Nixon had ordered an administrative reorganization of the of the uh, of the office that
Right. There was a
Fitzgerald.
RIF, a
Yeah,
reduction in force, and this guy was part of that. So yeah.
and so he reorganized the bureaucracy. They had to let some people go. They let him go. He said he was fired as retaliation for being a whistleblower and testifying in Congress about um, the uh, misspending, the maladministration of money that was going on at the Air Force. And because he testified that way, it wasn't long before he got fired. And it was retaliation. And the uh, civil service laws gave him a cause of action against the government and against officials in the government who had wrongfully terminated him. And he said, that gives me a right, gives me a remedy, and I get to sue not only lower level officials, but the president himself, because he's admitted he did it.
Right.
Uh,
Let me
so
stop
you,
you
ha-
there. Let me stop you there and point out I've been talking on my Twitter for days now about framing. And and I want to ask your opinion on this, King. So it, his lawyers, this Fitzgerald character, his lawyers framed it as surely the president cannot engage in an unlawful personnel action. That's what you were just describing, that this guy had a right under the civil service laws and a remedy for being subjected to an unlawful personnel action. Well, that's true. And that's what he argued, that the president couldn't be immune from violating the law, right, for
Yeah.
undertaking an unlawful personnel action. But the majority in Fitzgerald, they didn't frame it that way, right?
They did not, but they did discuss it. They discussed the problem of a court, one of the three branches of our government under the Constitution, a court diving into the motives of the president. To adjudicate that case, a jury or a judge would have to get into President Nixon's head and determine whether his motive was to fire the guy because of the administrative reorganization, which was a valid reason, or was his real motive to fire the guy as retaliation for being a whistleblower. And that's one of the things that really concerned the court in that opinion.
Right. And they framed it not as, well, can the president violate the law with impunity? They framed it as, does the action that was taken, the firing, fall within the scope of the president's responsibilities and duties? And because they framed the question that way, they then concluded that trying to reach a decision based on whether or not you prejudged it as an unlawful personnel action was just not the way to go about looking at it. Wasn't the way to go about analyzing it. And I see a lot of discussion of the Trump situation. It seems like the same thing. They're saying, well, he did all these things to engage in an insurrection. The president can't engage in an insurrection. But that's not really the question that the court wants to hear. And the way they've said to the parties in this case what it is they want to have briefed for them looks to me more like the analysis in Nixon. Can you agree with that?
I agree with that, because the circumstances are, other than criminal versus civil, they're almost exactly parallel. You have a statute that is alleged to have been violated by the president. You have a function that the president performs that includes organizing the government, the executive branch, as he wishes. He has discretion on that front. And which is it that is motivating him? And that's where separation of powers in the Constitution comes in. One of the justices, Chief Justice Berger, wrote a concurring opinion saying that the main reason we're finding immunity for civil liability is because of separation of powers. The Justice Powell's main opinion, the opinion for the court, used separation of powers as one of the grounds for the immunity decision. But Berger was even stronger, much stronger on that. And basically going back to the Federalist Papers and going back to Marbury versus Madison and the discussion about presidential, the function and nature of the president as a separate branch of government. And the courts have literally no jurisdiction to get into his mind, get
Right.
into regulating how he runs his office and makes his decisions.
Right. So let me ask you both. So I listened to a commentator today saying that this current Supreme Court, because we're not in 1982, Berger is not the chief anymore, John Roberts is. So this commentator was saying that because the court now is a conservative majority, or let's say a Republican president appointed majority, and that they're quote unquote a textualist court, that they will not view the grounds that the Supreme Court used in Nixon v. Fitzgerald as sufficient, that they will have concerns that Berger's argument that it's separation of powers and Powell's arguments, which is basically Margot's argument, that it's the structural nature of the unique constitutional character of the president, that since that's not literally in the text of the Constitution, that these justices may have trouble following Nixon v. Fitzgerald. What do you guys think of that?
I think that that's wrong, because our current court is actually looking more structurally, I think, at the Constitution than many have. If you look at the major questions doctrine that they've been talking about for the last couple terms, where they're talking about if it's something that the legislative branch wanted the agencies to do, they would have to be expressed in there. That's really a structural idea of what does it mean to be making the law. And I think that by analogy, what does it mean to be the executive? And that has to have that immunity. It's just implicit in it. And it's implicit in the structure. So I'm not using implicit in the sense of there's this penumbra that there's powers there. I
Right.
mean, literally, it is part of having a written constitution. So I don't think that being an originalist or a textualist is contrary to recognizing the structure of the Constitution, which I think that is the basis for the idea of absolute immunity.
Right. King, your thoughts on that?
I agree with Margot. I think when it comes to separation of powers and function of the each of the three branches, uh, that has a textual aspect to it. It's not interpreting a statute. It's interpreting the Constitution and understanding how it's meant to function. And I don't see any of the conservatives abandoning that principle uh, just because Congress passed a criminal law that might apply to something the president decides to do as part of his official function, depending upon what his motive was. Uh, Whether you're liberal or conservative on the court, they have to have some concern about a court or a jury deciding uh, major, societal implicating questions like we're looking at, based upon what the president's subjective motive was when he did it. Go back to Trump firing Comey. The liberal lawfare people, uh, uh, all of them, to a man, said that was an obstruction of justice because he did it to get Comey and retaliate against Comey and prevent him from bringing things to a, a grand jury to stop an investigation. It's
Right.
obstructing justice. Nevertheless, everybody agrees, a president has absolute authority to hire and fire for any reason or no reason at all political appointees like the FBI director. So to determine whether he committed a crime when he fired Comey, you've got to ask a jury to decide what was he thinking, why did he do it, what was his real motive.
Right.
Uh, that
So
that that's
doing
worrisome.
doing a lawful act for the wrong reason makes it a crime, is what it boils down to. And yeah. And the law has unfortunately drifted that way because we have all of these different areas of the law now where we decide whether something is a pretext or not. And for some areas of the law, that's a good analytical tool, and for other things, it's not. And this is one of the areas where it undermines other principles that are important. So I want to ask Steve here to jump in, tell us what he thinks in terms of the. Do we think the court will um, find there's immunity? Do you think they'll have problems with it because they're originalists? And do you think they'll overrule Nixon v. Fitzgerald?
I don't think this is an issue about overruling Nixon v. Fitzgerald, but I do want to take a couple of minutes to explain what the other side of the coin is here. The DC Circuit just issued a decision, which is now up at the Supreme Court, and the DC Circuit concluded that there was no absolute immunity on the criminal side, even though there is absolute immunity on the civil side. And their reasoning is you can disagree with it, but it's solid as far as it goes. And I want to just put it on the table so that people can understand what it is. First, they look at history and precedent, and they start with Marbury versus Madison, which is a seminal decision. And in that, Chief Justice Marshall addressed the whole issue of judicial review. Does the judiciary have the authority to review presidential actions? And he drew a distinction between discretionary and ministerial actions. And he said that if the presidential action is discretionary, then the judiciary has no authority to second guess it, to review it or second guess it. But if it's merely ministerial, then the judiciary can review it and can say that what the president has done is contrary to the law. So as that has come forward in history through the Supreme Court decisions, there have been various decisions that by the Supreme Court in which they have said that if there is federal law that mandates something, that makes it ministerial in effect, and there is no judicial immunity. It came up in a case that the D.C. Circuit cited called Ex parte v. Commonwealth of Virginia in 1879. So this is a Reconstruction era case. And the issue was whether a Virginia state court judge could be prosecuted for keeping blacks off a jury. And there was an argument that that the judge was immune because it was a judicial act in terms of what he was doing, presiding over a trial and selecting a jury. And the Supreme Court rejected that and said that as a result of the federal statute prohibiting discrimination, that he had no authority when selecting jurors to exclude, as they put it, colored men merely because they were colored. Such an exclusion was not within the limits of his discretion. So they said he could be prosecuted. And then more recently, you've got a 1974 Supreme Court decision, O'Shea v. Littleton, where the Supreme Court said, "We've never held that the performance of the duties of judicial, legislative, or executive officers requires or contemplates the immunization of otherwise criminal deprivation of constitutional rights. On the contrary, the judicially fashioned doctrine of official immunity does not reach so far as to immunize criminal conduct prescribed by an act of Congress." So there is some weighty authority out of the Supreme Court's own mouth that suggests that immunity doesn't apply on the criminal side. And if you draw the analogy, as people logically do, to say judges have immunity. They have absolute immunity on the civil side, but they don't have absolute immunity on the criminal side. Now, the cases that have held that have generally been in the cases involving bribery. And you can debate whether that's an official act. I mean, the whole notion of bribery is taking payment in return for an official act. So when the executive performs, or when the judge performs a function for which he's been bribed, is that a true official act or is it a corrupt act? So there's, number one, there's more Supreme Court decisions on the other side than you might think. Number two, I want to turn to the structural argument, and this is one that Margot mentioned, that Margot put forward, and I think very articulately. But what the D.C. Circuit there said was that that they didn't see a need to immunize a president in order to protect him or her from being deterred from doing his duties by the risk that some rogue prosecutor would come after.
I guess they never met Alvin Bragg.
Well, and the point I'm about to make is this: that they caveated their whole discussion by saying that they were only looking at federal prosecution, not state. They dropped a footnote where they said, "Oh, we do not address policy considerations implicated in the prosecution of a sitting president or in a state prosecution of a president sitting or former." So they just excluded from the discussion the risk that you get someone like Fani Willis, who is all too willing as the head prosecutor in Atlanta, Georgia, and therefore one of how many thousands of local prosecutors like that, to say, "Oh, I don't like what you did, Mr. or Ms. President, and I'm going to indict you under our state's criminal
RICO
laws
statute or
for what you did." So I don't want to be long-winded about this, but I do want to say that, number one, under the law, it's not completely clear to me how the Supreme Court will come out. I tend to agree with my colleagues on this call that I think that they will come out in favor of presidential immunity for official acts, but it's not crystal clear to me that that's the result. I do think that Fani Willis and Alvin Bragg, although that's technically for pre-presidential conduct, are an object lesson in terms of why there may be a need for immunity.
If I could jump in and add a
Sure.
couple thoughts, and actually a question as well. Given the Fani Willis and the Braggs scenario, and given how much we are seeing of lawfare against Trump, do you think that will be a impetus for the court to maybe find immunity where if it was not this kind of crazy situation, they might be more reserved? And connected to that, Steve, is that footnote that you mentioned, that if there's no immunity, there's no immunity. It shouldn't matter if it's a federal prosecutor or a state prosecutor. But they had to do that to distinguish from what we see here as kind of these rogue state actors, who there are so many more of them, to kind of make it so, oh, don't worry about that really bad situation that could happen.
Because
And
that'll never happen. Because we're going to
right,
drop a footnote that says we're not talking about that.
right, exactly. But so it's very helpful, Steve, that you mentioned what the other rationale is, because I do think that oftentimes we will see our side and be like, no, there's nothing else that makes sense. But I'm curious what you all think about the environment that our country is under right now, and whether that might prompt the justices to say, yes, we really do see the need for immunity. And it might have been something that was implicit in the structure, and the founding fathers never would have imagined that we're at the situation we are now, and kind of that pushes them over the edge to do immunity.
Yeah, and to that point, Margot, Steve and I were discussing earlier that, for legislators, there's a specific provision in the Constitution, the speech and debate clause, which the Supremes have interpreted broadly to say basically if the member of Congress is doing anything that is of legislative function, that's covered, that the member of Congress doesn't literally have to be on the floor of the House or the Senate. And so the other side sometimes argues, well, that shows that there isn't any such immunity for the president because there's no such comparable provision for the executive. But I am struck by, this is going to the point you just made, that the founders probably didn't think that was going to be a problem, because they lived in a world where the king wasn't being prosecuted, right? The king's men weren't being prosecuted. It was the king's men hauling members of parliament off to jail that they thought was going to be a problem, right? And no one was prosecuting judges unless they, did something that was personal, and everybody's going to agree, yeah, you can prosecute people for personal crimes. So I'm not so taken by this. Well, the speech and debate clause covers the legislature, and therefore that proves the president's not covered. So, Steve, you want to respond to her comment about the sort of the structure?
Well, I agree with the point you made before, and that Kingmaker made, which is that you're talking about acts that the president is doing in his official capacity, and for better or worse, assuming they're official and not personal, but assuming they're official, he's been elected to make that decision, and then to turn around and have somebody second guess that, or have a jury second guess that, and criminalize it and send him to jail for a decision he's made, is, I think, a very difficult result to reach. You say, well, we're not going to tolerate civil liability. Everyone agrees that the president would be absolutely immune on the civil side, because we don't want to affect his thinking or deter him from the risk that he then, after he gets out of office, spends the next 10 years embroiled in civil litigation from people who hate his guts and want to sue him for things that he did. And I think that there may have been before more of an assumption that you didn't have the same risk on the criminal side, because prosecutors are responsible people. Now, I say that as a former prosecutor. I was a prosecutor for 10 years. And I think that most prosecutors are, in fact, responsible people, and that it's an important job. But the recent history, and this is your point, Margot, recent history shows that there are prosecutors that are very aggressive, and also prosecutors that are prepared to be very political. And I don't see why it's any more tolerable to have criminal prosecution for an official act if you can't have civil liability for it.
I would add that if you take a look at judicial immunity, judges are except for bribery and maybe extortion, judges and their decisions and their deliberations are immune from civil and criminal prosecution. Am I right, Steve?
Well, the D.C. Circuit did concede when they said, well, judges can be held criminally liable. They conceded that virtually all of the cases are bribery cases. So, they didn't have a good example that was a non-bribery case.
Except for maybe that judge who wouldn't seat black jurors. Wonder what they were prosecuting him for.
Right.
But, the bribery, to me, King, do you agree with this? The bribery, to me, that's personal. You're not being prosecuted for the official act. You're being prosecuted for the fact that you've taken money for the official act.
Exactly. It's ultra virus. It's not part of your job description as a judge. However, if immunity, criminal immunity, goes by the wayside and is held not to exist for the president because there's, based on statutory construction and lack of precedent, etc., it's just not. We're not designed to give our presidents that kind of criminal immunity. What's to stop that as to judges? What distinguishes presidents from judges at that point?
Well,
or prosecutors,
yeah, but
same thing.
Let me pick up an example here that I think points out some of the difficulties here. You remember the Illinois governor, Rod Blagojevich, who got prosecuted and sent to jail for a number of years because when he had, there was a Senate vacancy, as I recall, that came open.
From Obama.
And, he was caught on tape saying basically,
how'd you like to be a senator?
Right. What's in it for me? But if you stop to think about that, I mean, I haven't lost any sleep about the fact that Rod got sent to jail for a number of years, but he protested, and his lawyers protested very loudly, that this was, this was official acts, and he was entitled to take politics into consideration. So I think
Just not money. He wasn't entitled to take money.
Right. I mean, I think we'd all agree that if he said, "I'll do it if you give me $100,000 or $1 million," then he goes to jail. But it's like, I'll give it to your favored candidate if you support this legislation that I've got pending, or if you support me in the next election. Then it gets a whole lot
messier,
because politicians have to take, well, I don't know if they have to take, but I think we all recognize that they're going to take political considerations into account when they're making political decisions.
An interesting footnote on that is that Blagojevich, or however he pronounces his name, is a Democrat, but he was pardoned by Trump. Or was his sentence commuted? It was one or the other.
It was commuted.
Yeah.
Yeah, but Steve just described basically what Justice Marshall wrote in Marbury versus Madison. The only distinguishing feature between President Adams and his political shenanigans and machinations was that he actually made the appointments, did all that he could, signed the commission, etc., to appoint the guy as a notary in Maryland, and Jefferson wouldn't fulfill the appointment. But the distinction was, as Justice Marshall said, yeah, Adams had a functional presidential right, is within his discretion to use politics to make those machinations. But once he finalizes it and puts pen to paper, then it has to be carried out by the successor. It was no longer discretionary. Basically, that's the Illinois guy. I can't say his name.
Yeah, no one can pronounce this guy's name except people from Illinois, I guess. So, okay. Well, that leads me to a question, and I'm wondering where Ship is. But hopefully he'll join. He's maybe snowed in. He's fighting off the Yeti, perhaps. So one question I have, and this is going to lead around to the question that Margot raised about, okay, let's say they do find immunity for official acts. Okay, now what? What happens then? But one point I want to raise for discussion before we get quite there is this question of political acts. So we unfortunately seem to have alighted upon this dichotomy of a personal versus an official act. And I understand why that is. The law often speaks about official acts, especially like in a bribery context, for example. But we're dealing with politicians, and some of them incumbent politicians, right? So how it seems to me it's going to be very messy to try to figure out whether something is political and therefore not official, or is political personal or not personal. And this is the way sort of the other side seems to be positing it, that, and the courts that have decided it too, that say, Trump was acting as a candidate, not as the president when he did X, Y, and Z. But that runs you smack into the problem that, well, the president doesn't stop being the president at any point in time, really, as long as he's in his term of office, right? But it's making me uncomfortable, this idea that nothing political can be official when you're talking about elected politicians. That doesn't seem quite right to me. And I'm wondering if the distinction should maybe more properly be private versus public, with public covering both political and official. What do you guys think of this?
I think that the framing should be, is this something that is in the realm of authority? Because the distinction between political and official to me is one of motivation. So if it wasn't, if could Trump have done the exact same thing if it was not Trump running, but it was another Republican against a Democrat?
Right. I've posed that too. What if Pence was the candidate?
Right.
Right. What if DeSantis had been the candidate? Or
What if the it was Pence and Trump hated Pence and didn't want Pence to win,
right.
so he was helping the Democrat. And every scenario comes back to motivation. So I don't think I think that you have to take the category politics or political out of it. That's based on motivation, and just ask, is this something that could have been within his authority? And then this goes back to discretionary, mandatory, all of that. But I guess that would be my take on it.
I'm troubled by that. I understand where you're coming from, and I'm very sympathetic to it. But look at Trump's speech on January 6th on the ellipse. That is a political speech. Suppose the candidate, in fact, had been Mike Pence instead, and Pence was the one that was behind, and he says, damn it, the election's been stolen from Pence. I want you to go up on Capitol Hill, and I want you to
make your voices heard.
Make your voices heard. Now, understand, I think Trump was within his First Amendment rights in saying everything he said, so I'm not challenging that. But in terms of whether it was presidential, I don't see a damn thing that's presidential about it. I see that as being an entirely political act.
But then a bunch of the other things don't seem to be, right? Like when he's talking to some of the public officials about fraud, right? Or when he's trying to decide, he's caucusing with the members of Congress about objections under the 12th Amendment. How in the world are we going to say that that's only political?
And let me just jump in. I would agree, Steve, that I don't see any part of that being a official act. So, and that segues to what Leslie said of what about these other things? And that's where there's going to be some line drawing. And that's, to me, the more challenging part is how are they going to distinguish? But I would agree with you that that speech was in no way official, but there are a lot of other things that I believe the indictment referred to that would fit in that.
Right. And nowhere, of course, in the indictment does the prosecutor say which acts are official, which acts are political, which acts, if any, he thinks are personal. So the indictment itself does not use that phraseology. And yet the question, going back to the question that the Supremes want briefed, their question asks, what is the answer? Is there immunity or isn't there for acts which are alleged to be official acts? And so this raises Ship's question about what does the Supreme Court mean by that? Do they mean as alleged in the indictment? Do they mean as alleged more generally by the government? Or do they mean that the defense is alleging the acts are official and therefore covered by the immunity? Now, Ship's tweet from the other day, he seems to think that the Supremes mean as alleged by Trump's counsel, that they're claiming that the immunity exists because the acts, whatever they are allegedly official. So let's stick first with that question. King, I know you were on that tweet. Do you think that's what the language means from the Supremes?
I first, to answer the question, do the Supremes mean as alleged in the indictment? That's what it seems to say, in my opinion. I don't think, if they think it through, that really works.
Right.
Because
we're going to get to that. Yeah, I agree.
Any prosecutor worth his salt can plead around the official act restriction. Same with the defense. Any lawyer on the defense can articulate officialdom as to any particular piece of conduct. There is a body of law that whereby an evidentiary hearing is held at the trial court level pre-jury trial to determine the scope or extent of immunity. And
Right, and that's routinely done, like in officer shootings cases where other government officials allegedly have violated constitutional rights and they're being sued. That's what the courts do. They hold a hearing to determine this question of qualified immunity.
so
And
I,
the judge makes fact findings. There's no jury. The judge makes the findings of fact and then applies the law to those facts and makes a ruling.
Yeah, I think what the Supreme Court was saying, I have a definite view on this. I think what the Supreme Court is saying is that they're looking at the allegations in the indictment. They don't care how the prosecutor characterizes them. They're saying if any of those allegations are in fact official acts, do you have immunity as to those acts,
Right.
which
So it's the
would
defense.
invalidate the indictment as returned.
Right, assuming there is immunity. So I tend to agree with that. I think Ship has it right that they mean as alleged by the defense to be official acts as part of the defense, because and then the court is going to say in objective reality, yes, these are official acts or they're not official acts. But I don't expect the Supreme Court to decide what's official and what's not official. Although if they say, what do you guys think of this? If the Supremes say the president does have immunity for official acts, we're looking at this indictment. We see these three acts definitely are official, like him deciding whether he wants to replace the acting attorney general. How in the world are you going to say that that's not an official act of the president? And so, to the extent that there's any official act, sort of the one drop rule, right? One drop of shit in the glass makes it a glass you're not going to drink, okay? So if there's one thing in there that is definitely official, the Supremes could take the position that therefore he's immune and this indictment is scrapped. And I'm sorry, Mr. Prosecutor, but you'll have to re-indict. And hopefully you'll be able to confine yourself to non-official acts next time. So that's certainly one way it could go. But what do you guys think?
So, Leslie, that was, I think, where my thought was at the beginning. And I think I'm still there. I do think that they're not going to go too deep into the indictment so that they can, as King said, make it very broad leveled. But as we were talking, I just got an email that was highlighting something that Ed Wieland, who is a very solid lawyer, noted that both of the parties in filing with the Supreme Court had framed the question as absolute immunity, but in granting it, the court dropped the word absolute, which could lead to some areas being absolute, some areas being qualified, and maybe only qualified. So that's something else to think through too.
I think I agree with that, Margot, but I think that they expressed it. They said uh, whether and the extent, and if so, the extent to which there is immunity, the extent to which would encompass a
Absolute versus
evidentiary
qualified.
hearing.
I agree. Yeah.
Right. I wasn't saying that it wouldn't be that they wouldn't consider absolute. I meant that they might also, I guess, split the baby in different ways than just absolute.
Right, just like the same court did in Nixon v. Fitzgerald. There was no justice who thought the president should not have any immunity. That didn't happen. 5 of them said it was absolute, 4 of them said it was qualified. So, I don't
But
see them going less than that.
just for our listeners' benefit, qualified means you're immune if your conduct or your action was made in good faith in fulfillment of your uh, uh, official acts. So, which again gets back into what I think is a problem that somebody's going to have to wrestle with: is to what extent will the courts want to get into the president's head as far as motive and good faith?
And the
When
majority in Nixon v. Fitzgerald said, no, we don't. So we're giving him absolute immunity. Oh, my. Okay, so um, one other question, and Ship has raised this, so I'm really sorry that he hasn't managed to join us yet. But He and I have been debating this question for a long time, which was it proper for the district court and the circuit court to just look at the indictment in making any of these determinations? And I've thought for a long time that this is something that the Supreme Court could potentially use to send this case back, even if they decide that there is not immunity, or if they decide the immunity is qualified, or if they're going to have to figure out, well, which acts are official and which acts are not official. Because I think it was legal error for Tanya Chutkan not to hold a hearing to determine an independent set of facts. So, for example, how in the world did the district court conclude which acts were official in the indictment? Because the indictment does not say these acts are official and these acts are political and these other acts are personal. It's silent on that point, completely silent. And an indictment will always be silent on that. No prosecutor is going to put in an indictment, we're indicting you for the following official acts, right? That's just not going to happen. So it's going to have to be figured out one way or the other. But against what standard did Judge Chutkan decide the acts were in fact official? She didn't take any testimony on the scope of the president's duties, or, which one of his duties do these things fall under. She didn't allow his lawyers to argue that some of these things are not official acts, or that they are indeed official acts and you can't indict him for that. So her analysis turns on what's in the indictment alone, kind of totally in a vacuum. What do you guys think of this?
What I think is that her view was that it doesn't matter if it's official, you're not immune, period, so I don't need to address any of that. The DC Circuit has upheld that.
Right.
So what she's done so far is logical if you accept their view of the world. If the Supremes say otherwise, then she's got to go back to go.
Right. Well, that's my point, is that she hasn't properly prepared a record on which the Supremes can make a final ruling, I don't think, if they decide that there's any kind of immunity. So this could be an easier case for the Supremes than a lot of people, especially people on the left, are thinking, because if all 9 of them could potentially say there's either absolute immunity or qualified immunity, just like they did in Nixon v. Fitzgerald, and whichever one of those views prevail, they could take the position that we can't say how that's to be applied in this case because the district court didn't hold a proper hearing. And so it goes back to her. And that kind of a hearing would not be done in front of a jury. So there was an article this week in the Washington Post in which a commentator, I think he was a professor, was saying, oh, well, what she could do, Judge Chutkan, is have the jury decide which acts are official and which acts are not. And we just howled with laughter at that, because that definitely is not going to happen. The jury is not capable of making that decision. And also, the point of being immune is that you don't get put on trial in front of a jury in the first place. So that's definitely not going to happen. But if they do send it back to her, she's going to have to figure this thing out for official acts before a trial gets started. And guess what? Once she rules on that, the president can appeal again. So all of these folks who are saying, oh, this case is definitely going to go to trial before November, I think are smoking a special kind of something, because I just don't see any chance of that happening. King, were you going to?
It goes to trial only if the Supreme Court, at least 5 justices on the Supreme Court, agree with with the DC Circuit, that under no circumstances is the president, a former president, immune for things he did while in office, official or not. Prosecution, you can go forward. If they rule that way in time for a case to be tried before the election, then I think that's what will happen.
Well, it's interesting. There was an opinion piece I read on just that point, and I don't agree with the writer at all, but that's what he was positing. He was positing that, of course, the Supreme Court's going to affirm, but that won't happen till the end of June. But according to him, that still leaves ample time because, of course, uh, he conceded that there would need to be at least a couple of months before you start a trial. So you could, but he said, Judge Chutkan could start trial in say September, or and then have Donald Trump in her courtroom for the last for
The last 2 months of
months
the
of the
election.
leading up to the election. And what would be wrong with that?
That's
I
perfectly
mean,
fine.
the public deserves to have a verdict here.
That
And he posited, oh well, she could accommodate him. She could have trial 3 days a week and let him go out on the campaign trail the other 4 days,
well,
or she could have trial every other week.
well, you guys laugh, but that is precisely what Jack Smith told the judge in Florida on Friday. He said that 60 or 90-day prohibition against moving cases forward in advance of an election that the DOJ has does not apply to him because he indicted his way before that deadline. And so he gets to move his case forward
Any way he
any
wants
way
to.
he
Right.
wants. And he
Right.
wants to try this case all the way up to and even past Election Day if it's necessary. So
Right.
if Judge Chuckton agrees with that, that's where we're heading. If
That's what will happen. That's right.
if
Yeah.
if the Supreme Court affirms the D.C. Circuit, which I don't think they will.
No, I don't think they're going to either. Because I don't understand how Nixon v. Fitzgerald doesn't really answer all of the questions and comes to the correct conclusion. But even if they go with the qualified immunity, so I just think there's zero chance they're going to say there's no immunity. That's just not going to happen. So if they go with the qualified immunity, then there's going to have to be further proceedings. And so then there's no way the case goes before the election. Now, I suppose what could happen is that the Supremes decide, well, we don't like what Nixon v. Fitzgerald is saying, but we do think that the uh, qualified immunity is the best that we're going to be able to do here. Um, and, I don't know. I just cannot see them saying there's no immunity at all. Margot, are you still on the
I
same page?
I am. I don't think that they're going to say there's none. I'm inclined to say there's absolute, and some areas there might be qualified. So the areas where absolute doesn't, they might come up with a kind of carve out for qualified.
Maybe that's what they'll do with the political acts as
Right.
opposed to
If it's
official.
something the person in good faith believed was an official duty, maybe something along those lines. But one of the things I thought was interesting is how you mentioned everyone's talking about the public has a right to have this trial. They're flipping on the head all of the constitutional protections
Yeah,
to
right. Well, it's
that
Barbara
the
McQuade.
defendant,
She was a
right.
U.S. attorney. She doesn't really believe in constitutional rights for defendants. That doesn't sound like.
Right. So, and there's no way you can't look at this and say this was rushed in every way, shape, or form only for one reason, to have Trump convicted before the election. And all of this kind of grinding of teeth, or whatever you want to say, that they're saying about all these delays in the Supreme Court saving Trump, it really is just pretty laughable.
Right. I mean, the objective reality is the Supreme Court has pushed this case quickly. They did not have to accept the application for a stay as the cert petition. By doing that, they cut off a couple of months at least. And normally, what happens after the cert petition is then you get a briefing schedule, and they're cutting that short too. So, but then that brings me around to the point we started with about this Colorado case, the timing. So we agreed, all of us, I think, that in that case, the Supremes are deciding the issue before the election on this Tuesday so that the voters of Colorado can know what the answer is. And I'm thinking that the Supreme Court collectively maybe thinks they're doing the same thing, with Trump's case by saying, we're going to decide this immunity question well in advance of the election so that everybody knows what the answer is, at least on that part. What do you guys think?
I'm going to pull a lawyer Bradley. I've got complete and total. That
Okay, you speculate.
I speculate that the way that issue was framed in the granting of the cert as to the immunity issue was bargained, and part of that bargain involved
You mean amongst the
amongst
justices,
the
just so
justices,
people,
and
yeah,
part of that bargain involved the timing.
probably. I think that I agree with that. Margot, you clerked for an appellate judge. Appellate court? What do you think?
Oh, I agree. I think that the timing was to get this resolved fast so that they would know what the answer was.
Right.
I think that I agree with all of that, but I think also that John Roberts is not the only institutionalist on the Supreme Court. And I think that some number of them are concerned that they not appear to be the lapdog of either party,
Either side,
or either candidate. And if they had let this thing play out in the normal course using their normal rules, which would have pushed it beyond the election, that they would have been perceived as favoring Trump. And so,
which is really sad because to me, I mean, I understand that, but to me, the right answer has always been do what you normally do. If you do what you normally do, then you can't be accused of favoring one side or the other. It's when you deviate from what you normally do that you run yourself into this problem.
right, but they've got to hit the problem here is that over the course of their 200 plus year history, they've made exceptions. They made exceptions in the original Nixon Watergate tapes case. Now, he wasn't the defendant there, but they put that on a very fast track. So they do put cases on a fast track from time to time.
We've just seen that with this Colorado case.
Well, and with Bush v. Gore.
Yeah.
So I understand why they did it, and frankly, I agree with it. I think that they are stepping up to the plate and doing exactly what we expect them to do. And as somebody pointed out earlier, it's not like they haven't already had some Trump cases. You know, they've got the Colorado case already, and now they've taken this on top of it. Plus, they've got the obstruction of justice case that applies generally to the J6 cases, but certainly will have application in Trump's case. So, and a very good point was made earlier within the last couple of days by Andy McCarthy, who said, you know, that could send the indictment back to the drawing board in and of itself without regard to this whole immunity issue.
Right. Now I have that on my list of things to talk about. So let's explain that to folks. So most people, I think, probably know that the Supremes have taken another case. The case is called Fisher, which is spelled Fischer. And this is a J6 case, and he was indicted under the obstruction statute, which is 18 U.S.C. 1512, C2. Excuse me, C is in cat 2. And the judge in that case ruled that C2 provision does not apply the way that the DOJ is applying it to the January 6th cases. Basically, that subsection of the obstruction statute was added in after the Arthur Anderson Enron thing because, hilariously, at that time, it was obstruction if you destroyed other people's documents, but not if you destroyed your own documents. And there was a lot of document shredding in the Enron situation. So the Congress said, that's a hole in the statute. Let's fix that. So they added this section that said basically if you destroy documents, it was obstruction, your own documents, it was obstruction. And if you did sort of, and I'm paraphrasing, this is not the exact language, but and if you also did anything of a similar character, it's also obstruction. That's C2. C1 is thou shalt not destroy your own documents. C2 is thou shalt not do anything else like that, you guys. Oh, here's Ship. Ship, we're just talking now about Fisher. So the DOJ has applied this section to the J6 cases because it's a felony section And a lot of the people, they were only going to be able to charge them with misdemeanors if they didn't basically distort this felony section all the fuck out of shape. So that's what they did. So they've said, well, these guys were trying to corruptly influence the certification of the vote in the Congress, and that's obstruction of justice under this C2 section. And one of the judges on the DC trial court, who's been doing a pretty good job on the J6 cases, Judge Nichols, said that doesn't make any sense, that to apply this statute that way. I don't think it applies. He actually said he did not think Congress was hiding an elephant in a mouse hole, because if you read the section the way the Justice Department wants to read it, it basically swallows the whole rest of the statute. You don't need any of the other sections. You just need that one section. And that's not normally how the courts read statutes, especially criminal statutes. So in this guy's case, the judge said, you're not, I'm not going to put you on trial for that. That count is dismissed as to you. And the Justice Department has appealed that case. And the Court of Appeals rendered an opinion in Fisher's case, 3 different judges. And this opinion in the DC Circuit is probably the worst opinion I have ever seen, not just from the DC Circuit, but from any federal circuit court. It is incomprehensible what it is that they actually decided to do. So one judge said that the lead judge said, oh yeah, basically, I'm really, really boiling this down. This is fine. The middle judge said, well, I don't think it's fine, but if you say that it's corruptly, and corruptly means that you really did it for a really bad reason, then that's fine. And then Judge Walker dissented, and he's like, no, was it not Walker?
Katsas.
Oh, Katsas. Sorry, it was Judge Katsas. He dissented, and he said, no, Nichols got it right. You guys are idiots. So that has now, the Supremes have taken that case. And I think, Ship, you tell us what you think, because you know as much about Fisher, maybe more than I do. I think the Supremes have probably taken that case in order to reverse the circuit and say, oh, yeah, we agree with Katsas and Nichols. This is not how you interpret this statute. And if they do that, then not only will all these J6 folks get the benefit of it, but so will Trump, because 2 of the 4 counts in his indictment are under this same statute. So if the Supremes say that the DOJ's theory on it is no good, then that's going to get rid of 2 of the 4 counts. There's problems with the other counts too, but right now those aren't being handled by the appellate courts. So if they do that, then McCarthy is right. Jack Smith's going to have to really do something different with his cut to pieces indictment. So Ship, you want to chime in now?
Yeah, I think had the Supreme Court not been inclined to take the case, they would have left the 2-1 crazy decision in place and relied upon later panels evaluating 1512 to sort of smooth out the edges and come to a consensus among multiple judges on the circuit to sort of make everything right. If the court thought that that was the right outcome. Maybe the rationale is kind of, indecipherable, but if all we're trying to do is parse out the rationale, later panels can do it because there's going to be a dozen more cases come through with people appealing 1512 on other grounds. So they could have done that. They wouldn't have to take the case. Andy McCarthy said something in a podcast about 3 months ago that struck me, and I went back and I started doing some research along the lines of what he suggested. He suggested that there is an existing history now that goes back nearly 2 decades of the textualists on the court stepping in and stopping justice repeatedly from using over-expansive interpretations of criminal statutes. A couple of other times, obstruction of justice statutes. They're not all obstruction statutes, but in every instance, the Supreme Court has stepped into a case where the conviction was affirmed on appeal and the court reversed the conviction 3 times, reversed the conviction unanimously.
Let me jump in there, Ship, because Margot and I had this same discussion. When was that, Margot? Where I was telling you, was it the Sussman case? or was it the do you remember this, Margot?
I don't. I don't.
Yeah, it was when we were on the other side, right? Everyone wanted this person to be prosecuted because I think it was that case where you were working on where they're behind the scenes they were having that research done. It was definitely
Oh, yeah, the Alpha
Sussman's
Bank.
case, Alpha Bank, and all of that nonsense, right?
Right.
And so it's not just McCarthy. I've been saying this for a long time. The court has consistently cut back on DOJ's rogue, sort of, far out there. They don't. DOJ doesn't think they're rogue, but prosecutions in basically white collar cases where it, it's often politicians, because the DOJ tries to stretch statutes that are fraud statutes, right? Or that are like the computer fraud statute they did this with, the mail in the wire fraud, honest services they did this with, where they've reeled these in because the prosecutors keep trying to stretch the fact patterns that they apply to. Um,
Yeah,
Skilling,
it's the
Skilling is the leading.
prosecutors.
Yeah, Skilling is
Yeah.
the leading example of this. So I
Well, yeah,
fully expect
actually,
them to do the same thing.
before Skilling was the Arthur Anderson case. That was the first one in the line. Arthur Anderson was 2005, where
Well,
the
Skilling is
Andrew
Enron.
Weissman.
It's the same. Yep,
Well,
Skilling is the
yeah,
Enron. Yep. Mm-hmm.
yeah. I think Anderson's 2005, Skilling's 2007,
Yep.
and Skilling was the honest services mail fraud.
Right.
And but what the court has done, see, justice wants to sort of push the boundaries whenever it can. It wants to reach out and embrace as much of what it sees as, illegal activity. And it, it uses statutes like they're elastic to just stretch them a little bit further to bring in that one. With Arthur Anderson being a classic example where Weissman prevails upon the judge to give an instruction that basically says you don't need guilty mind if your conduct is obstructive. So the facts of Arthur Anderson was that Arthur Anderson as a company had a document retention policy, and Enron asked Arthur Anderson to destroy documents, and Arthur Anderson destroyed those documents pursuant to its policy. Arthur Anderson had no idea there was a criminal investigation going on. It had gotten a subpoena, but it didn't know that the subpoena was a criminal investigation of Enron. And it simply followed its own document retention policy in destroying them, that it had in place for a long time, and it had followed it for a long time. So that was the first one. And then came Skilling. Then, and I wrote about all 6 of these in a Substack article. The one that is most analogous to Fisher is a case called U.S. versus Yates,
Yeah, this is the
where
fish case.
the fish case, the famous fish case.
All right, you guys. So this Yates case is literally about a fish, okay? And then the Fisher case is about obstruction. So these are 2 different
They're both
cases. Don't get
obstruction.
it confused.
Right.
I
They're both.
know, but the
Yeah.
fish case is not Fisher.
Right. No, Yates. It's about a fish processing company that was undergoing an inspection by FDA or whoever, and they destroyed a bunch of fish.
They threw them back, and they got
Yeah,
prosecuted federally
right.
for throwing fish back.
Right. And the question was whether they had tampered with records, documents, etc.
And the
And
government actually argued that that fish was comparable to a document.
exactly, the government said, well, but it was the same kind of or otherwise kind of situation. But it's the government is using the same argument now that got rejected in Yates, which was that an or otherwise residual clause can be disconnected from the primary clause. That the or otherwise clause just opens the world of whatever conduct, rather than simply being the same type and kind of conduct, just not exactly what the primary clause describes. And I don't have the statute in front of me, or I'd use the exact language to make it clear. But there have been 6 of these cases. Then there's the famous the Bob McDonnell case, the Virginia governor, where he's prosecuted by public integrity section headed up by Jack Smith.
Yep.
And the question there was, he accepted gifts from a variety of people, Under Virginia law, it's a historical tradition, and it's not illegal for the governor to accept gifts. Well, in exchange for, well, not necessarily in exchange for one of these gifts, but alleged by Jack Smith as a quid pro quo, the governor, McDonald, arranged for a particular gift giver to have a particular meeting with some head of some state body.
Commission, yep.
Yeah, nothing was promised. He just agreed to set the meeting up. And then the meeting takes place and nothing happens. And Jack Smith prosecuted him for fraud on the basis that just setting up the meeting in exchange for a gift was an official act. Setting up the meeting was an official act by the governor. And the Supreme Court reversed that 8-0 and said, no, it's not. That's not any activity by the state government setting up a meeting. So again, you have this kind of crazy, expansive definition that produces a conviction. The conviction gets affirmed by the appellate court, and the Supreme Court comes in and says 8-0, no.
That's not how that works.
Right.
So in full disclosure, Steve's law firm represented the governor, and Steve worked on that case in the Supreme Court.
All right. So big win there. Then we have the two cases that follow that are significant and I don't remember all of the details. And these weren't obstruction cases, but they're the same kind of, slap on the nose of DOJ with a newspaper.
Did you include I should read this Substack. Did you include
Christie's aides?
Oh yeah, okay. Did you include the computer
I don't
hacking?
think so. No,
yeah, that's another one. Same thing. Expansive application. The Supreme said, this is a hacking statute. Yeah.
Right. So then you have Chris Christie's aides with Bridgegate or whatever that thing was. They get convicted. That gets affirmed on appeal, and the Supreme Court reverses. I think that might have been 7-2 or 6-3. And then the last one was Mario Cuomo's aide. Not Mario Cuomo, Andrew Cuomo's aide, who leaves state government and takes a position with the campaign. And then while with the campaign, he basically, the allegation is he used his influence to affect government policy. And that was said to be corrupt because he was de facto controlling the government agency who he was influencing. And so, so in effect,
so words no longer have any meaning in this context.
They prosecuted a private citizen under a public corruption statute, and the Supreme Court said, no, you can't do that. Congress made it about private citizens. You don't get to decide that, or Congress made it about public officials. You don't get to define public official on a de facto basis to throw in a private citizen.
So the through line to all of these, you guys, is that the DOJ goes crazy and it wants to criminalize stuff that it doesn't like. And they just decide it fits somehow into this statute. But the sad travesty is that most of the time the trial judges and the appeals courts go along with it.
Right. So you had and as the Supreme Court has said, and I think Chief Justice Roberts has said a couple of times in a couple of these opinions that he wrote, said, look, that may be objectionable conduct. Right. And if Congress wants to make it illegal, Congress needs to say it's illegal. They didn't say that in the statute you're using. So it is a consistent, and I'd like to point out some of these cases cut across ideological lines.
Right, they do. The politicians are left or right, it doesn't matter. Yeah.
Yeah, when Andrew Weissman got reversed, that was Ruth Bader Ginsburg who wrote that opinion, and it was 9-0.
Right.
Clarence Thomas and Antonin Scalia were right there, cheering her on. And same for, well, a little different with the Jack Smith and McDonald decision, because that's where Justice Scalia died while the case was pending. It ends up 8-0 for that reason. But again, 8-0. You've got, again, everybody from Ruth Bader Ginsburg to Clarence Thomas all agreeing justice has overstepped its bounds. So there is a consistent history going back now to 2005 of sort of this composition of the courts saying, justice can't just run wild prosecuting what it thinks is a crime without a solid foundation and a statute. Fisher is the same thing. This statute in Fisher, the provision that they're using was an amendment to the existing statute. It was an amendment that came after Enron. It's part of Sarbanes-Oxley. What it's designed to address is the fact that if you read this obstruction of justice statute, everything is almost everything in the statute is like a third party does something at the direction of the defendant. Cause any person. It's
Right.
always,
Because historically, that's what would happen. The defendant wouldn't be destroying evidence himself, but he would be getting other people to do it for him,
exactly.
or intimidating witnesses or jurors or judges, etc.
Exactly. And one of the problems in Arthur Anderson was it was Arthur Anderson destroying the
Right.
documents. And that wasn't a good fit for the statute, because the statute always refers to directing third parties to do things. Whereas it was Arthur Anderson's employees down in the basement with the shredder destroying the documents. So they create this residual clause that is essentially intended to make it first person as well as second person, because or otherwise can includes not just telling a third party to do something, but doing it yourself.
Right. All right. So it sounds like you and I are in agreement. Kingmaker, Margot, you got any views, Steve, on we think the Supremes are going to reverse the circuit again?
I absolutely agree. I think that this is going to be a reversal. I think they wisely will be doing it in a non-Trump case.
Exactly. Yes.
Right.
Yes. Yes. Yes.
And that will also impact the trial and the timing of it. So I absolutely agree on all fronts. And I'm actually going to have to log off here.
Ah,
So
okay. Well, thank you,
we'll
Margot.
use this chance to thank you all for chatting with me.
It's great to have you here.
Thanks. Bye-bye.
But now that Margot's left, I'll tell you all kinds of stories. But but in the meantime, I agree. I think the court will reverse that, uh, significantly narrow the reading of the statute, and it will significantly change the case against Trump, because those two counts under the obstruction statute are the main underpinnings of all of the January or most of the January 6th stuff.
Right. They've shoehorned all of the bad facts that they don't like into the conspiracy to obstruct that. Yeah.
Right. The comment I have is that we're focused tonight on the impact on the Trump prosecution, but more generally, and Ship knows this better than anyone, uh, the bunch of the January 6th defendants uh, have been gravely over prosecuted because this statute has been applied to take conduct that would otherwise be a misdemeanor and jack it up into a felony. And I agree that the Supreme Court's going to reverse on this, and it's going to have an impact on a lot of the J6 cases. I don't want to minimize the seriousness of J6 overall, but there were people that committed felonies during that day, that fought with the police, that injured people, that did things like that. And there were a bunch of people that did things that were of a much lesser significance, but justice has taken an extremely aggressive posture, stretched the statute to get to the result they wanted. And, I think it's high time that the Supreme Court called them on that. And it's a shame that it's had to take this long and go this far to get to that result.
So, Ship, do we want to talk about Brock or not? Hey, Ship.
Sorry, I couldn't get the microphone. Yeah, we can. Brock is a related but different issue, because Brock survives even if Fisher survives. So if Fisher survives, if the 1512 count, for whatever reason, survives Fisher, the Brock decision from Friday, and I can explain it just a minute because I'm confident not everybody knows what I'm talking about.
Right.
But on Friday, well, what I'm trying to say is, even if Fisher survives, the Brock decision on Friday so dramatically alters the sentencing guidelines as they apply to the 1512 count that the days of getting 4, 5, 6 year sentences for 1512 are gone. and it will be more likely 18 months to 24 months, maybe to 30 months in the worst cases. So you're going from people, rather than serving 5+ years, you're looking at a year and a half. So what happened is, from day one in the 1512 counts, if a defendant wanted to plead guilty in order to gain the benefit of acceptance of responsibility under the guideline calculation, which is a manual for determining what a recommended term of imprisonment would be, which is where the judge starts after he comes up with the recommended term using the guideline. If a defendant wanted to get acceptance of responsibility, which brings your guideline level down, and the lower the level, the shorter the sentence, they had to plead guilty, and the government was demanding stipulations in the plea agreements that the defendant agree that 2 enhancements under the guideline had to apply. And there was a +3 level enhancement and a separate +8 level enhancement. The +3 level just applied because the proceedings before Congress were actually halted. In other words, it wasn't an unsuccessful attempt, they actually pulled it off. So whenever the obstruction is actually accomplished, there's an extra 3 levels. If violence or property destruction occurs during the course of obstructing the proceeding, that's an extra 8 levels. So the combination of those 2 factors, which in many defendants' cases was present on January 6th, you did have the proceedings were halted. So everybody's going to eat the +3 because the proceedings were actually halted. And those that engaged in violence or broke windows or did other kind of property damage, they're going to eat the +8 as well. And the government was demanding in the plea agreement that if you wanted to plead guilty, get the benefit of pleading guilty, you had to agree that those 11 levels would also apply. Well, this was sort of the magic bullet that got the government to the sweet spot that it wanted to be, which was in the range of 3.5 to 5 years, even for people that pled guilty. And that's what they really wanted. They were anybody that they felt fit within that category. They wanted a lengthy sentence, 3.5 to 5 years. And that's a significant sentence under the federal sentencing guidelines. Both of those enhancements apply to circumstances where the administration of justice is interfered with. And defense lawyers, including me, from the very start said, hold on, counting the electoral votes has nothing to do with the administration of justice. The administration of justice is the criminal justice system, the civil justice system, proceedings like before the SEC or immigration court, any kind of adjudicatory function where rights are influenced or defined. That's the administration of justice, not Congress counting electoral votes. And every judge, except one, I think it's one, it might be 2. Every judge except one agreed with the government that those 11 levels applied, that the proceedings before Congress, that the phrase administration of justice was sufficiently broad that the proceedings before Congress could fall well under that umbrella. I mean, it's just, to me, it was always just like Alice in Wonderland reasoning. It just didn't make any sense to me. We all know what the administration of justice is. But the judges were, I mean, they were tying themselves in linguistic knots to come up and make the administration of justice include proceedings before Congress. Well, on Friday, after this has been going on for 2.5 years, on Friday, in a 3-0 decision from the Circuit Court of Appeals, they ruled that the proceedings before Congress, the counting of electoral votes, did not implicate the administration of justice, and neither the 3 nor the 8 level enhancements apply at sentencing. Well, this changes everything. I mean, I just give an example. I've had 2 clients who were at level 28 when they were sentenced. Their guideline range was 78 to 97 months. You take away those 8 levels, now their guideline range is 24 to 30 months. So from 78 to 24, somebody do the math, 54 months, 4.5 years is the difference in what where the judge is now going to start on resentencing. It essentially, you know, it essentially kicks the legs out from underneath everything the government had tried to establish going back to the initial cases. Just a small history lesson. The very first case was a defendant named Paul Hodgkins. He's the first person to plead guilty to the 1512. He was the first person to get sentenced to the 1512. The government asked for the +3, and the court gave it to him. His guideline range with only the +3 was 15 to 21 months. Okay, so long ways from where the government sort of hoped to get, 15 to 21 months. The judge in the case gave him 8 months. 8 months for subverting democracy, if you listen to the Department of Justice, basically. And so that wasn't going to do it. They could not prosecute hundreds of people and get single-digit or teen numbers of months sentences. So what happened was, that's when they started offering plea agreements with a stipulation to both enhancements. The second case was my client, Jake Chansley. I didn't handle it at sentencing. I picked him up afterwards. Jake Chansley got a plea offer that had both the +3 and the +8. He had to accept them. That made his guideline range 41 to 51 months, and Judge Lambert gave him 41 months. 4 months apart, 5 months apart, two different defendants. One got 8 months, one got 41 months, and the difference was the government forcing in the plea agreement the defendant to accept the 11 levels. Now, those 11 levels don't apply to anybody. All of these cases are going to have to come back for resentencing. And all of these sentences are going to be ratcheted downward dramatically. And I think, with only the exception of a handful of judges, maybe 4 or 5 of them, I actually think a lot of the judges are going to be a little bit relieved. I think some of them were kind of uncomfortable with the length of the sentences they were giving.
Well, I don't have any sympathy for judges who are uncomfortable but won't do the right thing, like
Well,
apply
I
the
don't
actual
disagree.
language.
I don't disagree, and they should not have gone down that road. But in a lot of ways, we've talked about this. I think there was a little bit of a herd mentality that developed, and some of the judges got a little bit stampeded by the others that wanted to hammer everybody. And they've got that collegiality behind the scenes. You can't have one judge at one end of the courthouse given 5 years probation for marijuana, and the other judge at the other end of the courthouse given 5 years prison for marijuana. And
if you're not going to stand on your own intellectual thoughts about things, then you shouldn't be a judge.
I'm not disagreeing with you. I'm telling you, I just think that's the way it played out.
Oh, I know that's how it is, but it's disgusting. And I can't even overstate how disgusting I think it is that a judicial officer who has this much power over other people can't be intellectually honest. It's revolting.
Now, let me give you a couple of examples. Guy Reppett was the first defendant to go to trial and lose and be sentenced. And he was sentenced, I think the 1512 drove his sentence, and he was sentenced to 60 months or his new guideline range is 30 to 30.
What is all that? What is all this noise behind you?
I'm in the kitchen, so I'll move out of the kitchen. His new guideline range is going to be 24 to 30 months. His new guideline range is going to be 24 to 30 months. He's already served 34. He's overserved what his expected sentence will be.
Right, so because judges don't have the cojones to, think for themselves.
So his lawyer yesterday, on Saturday, has already filed a notice for bail pending appeal, because his appeal isn't over yet. His appeal is pending. And he's now, the argument is, I'm certainly going to win this issue on my appeal. I'm certainly going to be entitled to resentencing. And at resentencing, my guideline range is going to be less than I've already served, so I should be subject to a time-served sentence. I should not have to stay in jail until my appeal is finalized. So I think this coming week...
That should work.
Yeah, I think this coming week, you're going to see a flood of motions for bail pending appeal as the lawyers begin to do the math for some of these clients about how long they are likely to spend, how long they have already spent, and how long they might spend before their appeal is resolved.
So people are going to ask, they've been asking me already, so what about people who've already served or their cases are finished or they pled guilty and they've waived their right to appeal? So can we explain this for
Well,
folks?
okay, so an interesting one is where people have waived their right to appeal. As to the guidelines, there's not an easy way back. When
Right.
you waive your right to appeal and your case is final, there's no real jurisdiction for the district court unless you argue, unless you file a 2255 and ask that your sentence be vacated. But
Right.
you've got to have a constitutional basis to file a 2255.
Right. 2255 folks is a habeas corpus claim that you can bring in after your appeals are done. But I mean, you can't waive an illegal sentence, but I'm not sure that this situation is an illegal sentence
Correct.
in the
It's
way
just
that that's intended to mean. Yeah.
it's a legal error, but it is not necessarily an illegal sentence.
Right.
An illegal sentence would be, and we talked about this offline. In my opinion, illegal sentence will be if Fisher gets thrown out, if the 1512 count gets thrown out, all the plea agreements say that the defendant has waived his right to challenge on appeal the constitutionality of 1512. I don't think that's enforceable. Because basically, if that is enforced, then the defendant is in prison for a non-crime because the
Right.
Supreme Court has said there's not a crime here. And now you're serving a sentence for a crime that doesn't exist. And I believe that's an illegal sentence. And I don't think that that illegal sentence can hide in the safe harbor of a waiver of appeal.
Right.
Um,
Probably not. I agree. But that's a good illustration of the difference between the two issues.
yeah, one is just a sentencing error in the calculation of your sentence, and the other is actually a sentence that should have never been imposed. But again, I actually think, I think that if defendants are making 2255 applications claiming ineffective assistance of counsel for not properly preserving the errors here with objections, I think the judges are going to be inclined to just go ahead and give them that, bring them back in and resentence them.
Yeah,
Uh,
maybe.
and not have, otherwise you set up a circumstance where you've got one group of 1512 J6 defendants who get the elevated sentences, and you get another group of 1512 defendants who get the benefit of the reduced sentences, all for doing the exact same thing on the same day.
And just because it takes the Court of Appeals a year and a half to figure it out,
Yeah,
it's
yeah.
wend its way through the system. Right.
And you got I mean, I've called it this, I don't know the technical place, but when the government is winning 99.75% of trials, when they demand a term in a plea agreement, it's kind of like a contract of adhesion. You don't have the ability to bargain that term away. Because
Right.
they tell you,
Your only bargain is go to trial. Well, you're going
go
to
to
lose.
trial
So
where we win all the trials. So, good luck to you.
right. No, plea bargaining is a total disaster, and really the courts need to do something about it. But there's a bunch of problems with that, limitations on them that make
Well,
that difficult. We can talk about
what
that another day, but
yeah, what I
yeah.
wanted to talk to you about doing is you want to be sort of a shining light on some of these problems from a policy basis. To me, this should be an inflection point for GOP members of Congress to say, you know what? This venue provision that traps defendants in a foreign venue where they have got no chance to defend themselves, either trial, maybe even not at sentencing, it's fundamentally unfair. They should have alternative venue provisions that allow a defendant to be tried in his home district. Because what interest does justice have in the location of a trial? The evidence is the same. They get unbiased witnesses. If witnesses in the District of Columbia can be unbiased, and witnesses in the District of West Virginia can be unbiased. So, and my view is justice should have no interest in where a case gets tried. All their interest is being able to present their evidence to a jury and obtain a verdict. That's it. So the idea that that the Department of Justice's District of Columbia U.S. Attorney gets to play on this home field and have this
Yeah, the
home field
problem.
advantage where it can't lose.
Right. The problem
And,
is that the Constitution is what creates this issue, I
but I
think,
think that
because
the Constitution says the defendant shall have the right to be tried in the district where the crime occurs.
right, I agree.
And,
It
and
does
that can
say
be
that.
waived. And that can be waived.
Right. And I agree with you that therefore the Congress might be able to legislate on this if they did so in the nature of making it an election for the defendant.
Right.
Yes,
And the government does not have the ability to object.
right. So I actually have that on a list of things that I'm going to hopefully, if not this year, then next year, be publishing about. Look, these are the things that need to be changed, and here's some ideas for how that needs to happen. And this is one of them because it is nuts to me that people can come here as simple tourists, right? Like I had cases when I was practicing where tourists come to DC and they pick up a traffic charge or they pick up a DUI, right? And they're from Idaho or Iowa, or they're never coming back here, and yet they have to keep coming back here for their case, right? I mean, it's just kind of craziness.
I had the same, well, there's a solution for that, and it's Rule 20. But, the government in these, Rule 20, just for those, allows a defendant who wants to plead guilty to have his case handled completely where he lives. A
Right.
judge would be assigned where he lives. The prosecutors would be where he lived. But you have to plead guilty.
But you have to plead guilty, right?
Okay.
Otherwise,
So,
you get to pay to come back here 3 and
right,
4 and 5 times for your case, which
right.
is insane.
Yeah, but
And so I
that,
had.
there's another side to that. There's another side to that coin, Ship, and that is you're a Texas outlaw. You go up to Vermont and you rob a bank.
Yeah, but we're not
No,
talking about that.
no, just a second.
We're talking about the
Just,
District of
just a
Columbia.
second. We're talking about making a change to the federal rules that would apply universally. And you're saying that if a Texas bandit goes up to Vermont and
No.
robs a bank, they could require all of the bank employees to come down to Texas to testify in that case. That's bullshit.
No, we're not saying that. We're saying that the Congress should pass a statute that says when people from the various states come to the District of Columbia and then are charged with a criminal charge, that they can be tried in their home state.
Oh,
That's
okay.
it.
So if a bank robber comes to the District of Columbia to rob a bank, then they get to require all of the District of Columbia citizens who happen to be in the bank that day to come to Texas or wherever it is they live to testify. Because the District of Columbia, of course, is special.
Yeah, well, because no one's going to come to the District of Columbia to rob banks unless they're from Maryland or Virginia. So cry me a river about the witnesses who have to travel for
Well,
their case.
I understand Steve's point. I do. But I think the practical reality is in most cases, about 85% of the witnesses are just government employees. You have a small handful of civilian, citizen witnesses. But
Right.
I understand that complication. That's certainly
But
a
the
policy
District of
that has to be
Columbia
weighed.
is unique. People come here from all over the nation to see the federal government, right? That it's not like anyplace else.
But let me give you an example, though, that is a similar rationale, but a different thing. It's like I can't tell you the number of cases that I know about. I only handle a handful. Like of people who come to Yosemite National Park to see the waterfall and get cited for drunk driving in the park, and
Right.
they're from everywhere.
Yeah, it's true.
And so, but if they want to, so there should be a mechanism that in that kind of case allows the person to not have to come back to the Eastern District of California to resolve their drunk driving case.
Right, when they're from Georgia or
Right.
someplace.
Well,
right, exactly.
just
it's
a
it's a
second.
tourism venue.
No,
That's what
just
we're
a
looking
second.
for.
It's one thing if they want to plead guilty and you acknowledge that the current law permits them to
Yeah,
plead guilty
it
where
does.
they are.
Right.
But
See,
if they're
but
not going
that
to
would be
plead
true.
guilty and they want to go to trial, then you're saying that somebody that comes to Yosemite and gets drunk and drives in Yosemite while they're drunk should be able to go back to Georgia where they live and require the officers to travel all the way to Georgia to testify that they were drunk. Because, of course, they have a right, or should have a right, to come to California, get drunk, but have that adjudicated, make all of the witnesses travel all the way to Georgia. That's bullshit.
They do have a right to do that.
This is the old prosecutor talking. You hear him?
Oh, I did it for 21 years. I understand the I understand the countervailing views.
Yeah.
So, but but as to the J6 defendants, they are in effect trapped. They
Oh,
cannot
and
defend
they're
themselves.
being prosecuted by politically motivated prosecutors and getting convicted by politically motivated jurors. So,
Yeah,
who are we
but
fooling?
I can certainly, I think a bridge here would certainly have been the government's willingness to allow Rule 20 proceedings, but they won't. They've turned
Right.
down Rule 20 requests.
Well,
Right.
Rule 20
that's a
is
different
where
issue. That
Rule 20, just for everybody else, is where you want to plead guilty and you agree to be sentenced, but you don't want to have to come cross country to have it done. You want to do it in your own federal court, and this happens all the time.
Right.
But in these cases, the U.S. Attorney's Office, the Department of Justice has said no, they will
And
not
they
agree to that.
shouldn't be allowed to do that.
uh,
They
uh,
should not have a veto on that.
okay. I agree completely on that. Not now. Am in complete agreement with you.
Yeah.
It's one thing if you want to make them come to you, you want to fight it. You want to fight it. I think you ought to go to the district where it happened. But if you're saying I'm prepared to plead guilty to it, then I agree with you that it ought to be in your home district.
Yeah, because
Okay.
really what it really says at the core is the Department of Justice wants its hometown judges. It doesn't trust foreign judges to be as, sensitive to the happenings of the day because they weren't, a quarter mile away looking at it through their, chambers windows.
Right. Right. Okay. So let's see. What else I got on my list? We were going to talk about some timing stuff. So one question that we had is um, about the New York case, and so let's address this briefly. Ship, mute your microphone. Ship.
Okay, I'm back in the kitchen again. I'm handling
Yeah.
dinner.
Turn your mic off.
I've been outside snow blowing 4 feet of fresh snow in the
Oh
last
my
48 hours.
goodness. Okay, so we had one question about, and it was phrased this way, basically saying, since Trump, quote unquote, lost his appeal to stay this $450+ million judgment before appeal, are all of his appeals exhausted? So just so people are clear about this, the Trump did not lose his appeal on that issue. He has appealed to the appellate court in New York. These are New York state courts, not federal courts. He's appealed to the appellate division for a stay so that the attorney general there cannot begin to try to get money out of him on the judgment. Okay, so if you get a judgment against someone, they don't just fork the money over, although sometimes they might, I guess. But basically, there are procedures that lawyers use to claw money out of people. And you can prevent the other side from doing that while you appeal, but only if you post a bond, so that if you lose on appeal, the money is sitting there, and then basically the other side gets their money. So the thinking on this is that the legal system does not want people using the appeals process as simply as a delay tactic, not to have to pay judgments, because then everybody would appeal everything, and that would clog the courts. And you can agree with that or disagree with that, but that's the rationale. So to basically stay enforcement of the judgment, you have to post the bond. It doesn't really have anything to do with whether you can do the appeal or not. You can do the appeal even if you don't post the bond. You just can't keep the other side from trying to execute on the judgment while you're appealing. So his appeals are definitely not exhausted in a legal sense. But the other thing is that his lawyers filed with the appellate court a motion to stay the judgment without posting a full bond. And one judge on the appellate division denied that temporarily, but did lift the provision that the trial judge had imposed, saying that the president and his sons, I think both, and the businesses couldn't do business with banks in New York because that was one of the things that's keeping them from getting the bond in the first place. So that has been lifted. But even the Court of Appeals has not yet decided the issue about whether Trump has to post the full bond. One judge decided it on basically on an emergency basis. And next month, the full court is going to hear that issue. So far from his appeals being exhausted, this is just basically minor technical skirmishing at this point on the technicalities of posting the bond, and doesn't really have anything to do with whether the appeal can be had. You do not have to pay for the privilege of an appeal in this country. you do have to post a bond if you don't want the other side to try to execute on a judgment, which is two different things.
Leslie, do you know the timing or the schedule for the entire court to
It
review it?
is I think the within the 20s of March, so it's like in the middle of March the full court is supposed to hear that.
That's about when the judgment, uh, the automatic stay for the judgment ends, I think. So if
Right. Yeah,
if
because there's the 30-day automatic judgment stay that just applies to everyone, right?
so just as that's running out, Trump's going to be at the mercy of this court, which could deny it, as the one judge did, uh, delay it. So uh, the attorney general has announced she's going to be seizing assets, mainly buildings, to collect that judgment. Do we have a Texaco situation?
I mean, I'd like to see them run those buildings or try to.
Do you understand what I'm talking about
Yeah,
with
yeah, but tell
Texaco?
folks. Yeah.
They'll gladly seize the buildings.
Well,
But I think that the issue here, as Leslie said, on one level, it's a technical issue. On the other hand, it's a very real issue. The point is that Trump, of course, doesn't want to let Letitia James get her hands on any of his properties. And uh, the question here is whether that's going to happen. The Engoron issued this ridiculous decision uh, that, and Trump's attorneys properly sought relief. And this it went initially under procedure to a single judge who gave them some relief. It's not like the liberal press says he rejected Trump's appeal.
Right.
That's
That's
not
not
right.
what happened.
That's not what happened. He gave them substantial relief. Number one, he said that Engoron's thing blocking the sons from being involved in the business was stayed pending the appeal so that they can continue to run the business. Number two, he invalidated the provision that said you couldn't seek a loan from any bank that does business in New York, which is virtually every bank. So if you're going to get a bond pending appeal, you've got to likely do business with a bank. So this opened up the possibility for Trump to do business with a bank. Now, the question that remains is whether that gives Trump enough wiggle room that he can now get a bond for the basically 500 million that they're looking for, or not. If he can't, then Letitia James is going to start trying to seize things like the Trump Tower. That's what's at stake here.
So,
that was the reason for my question
yeah, about
regarding
Texaco. Explain to
Texaco.
folks what you mean. Yeah.
Okay, back in the 80s, I think, the oil company Texaco uh, got hit with a bankruptcy a bankruptcy uh, size judgment against them that they could not pay out of liquid assets. They could not get a bond to stay the execution, and the plaintiffs were about to go seize all their oil refineries and oil and gas pipelines, etc. So they filed Chapter 11, and that stays execution of the judgment. They stayed in Chapter 11, Chapter 11 bankruptcy for about 2-3 years, and then came out having gotten the judgment reduced substantially, settled with some creditors, and came out as good as gold.
I don't see Trump filing for bankruptcy with all of his companies, but he's got this behemoth of an operation in various companies, and so I don't know the structure of that well enough to say could he do it for some and not others, and basically kind of put the kibosh on the judgment, but still have enough else going on.
One thing he could do, but I don't know who the legal owners of all these buildings are.
Right.
But if they're in different corporate entities,
Right. That's what I'm saying.
every
It's
time Miss James tried to seize one, put that one in Chapter 11. And we
right. That's what I'm saying. Can you play that kind of move the move the peanut around
yeah,
game?
shell and pea game. Yeah.
Yeah. Right.
Uh,
So well, we'll see. But okay. So but that's what's going on with that. The former president certainly does not have his appeals exhausted in that particular case. Okay. So we're getting to the end here for tonight. Let's see. And so, King, let's come back to you on Georgia. So the the judge heard closing arguments, and the Twitter following on that was hilarious.
it was it's crazy.
Yeah,
My
I mean that
my
was some of the worst and some of the best lawyering I've seen.
yes, it was. Um,
It was painful.
some of it was painful to watch, but at its core, there's enough there to support a finding of both an actual conflict and certainly an appearance of conflict to disqualify Ms. Willis and Mr. Wade. Uh,
Okay,
the
is that what
in
you
my
expect? You
in
think
my
that's what the
view,
judge will? Do you think that's what the judge will do, though?
um, there was a legal argument on Friday by the state that appearance of conflict doesn't apply to prosecutors. There has to be an actual conflict, and on the
Which makes
actual
total sense. Why would you want the public to have faith in the prosecutor's office and the way that they conduct themselves?
that 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 was pointed out many times in many different ways by the defense side.
Trust us, it looks terrible how we're prosecuting all these people, but really, we're doing it the right way.
That
Okay.
and my I'm not going to predict. If I were the
Mm,
judge, I would kick them off the case. I think they have uh, tarnished their reputation, the county's reputation, the state's reputation, and nobody in the world should have any faith in justice being done going forward with
by
uh,
these folks.
by these
Yes.
folks.
Yeah, right. Now, there was apparently a bar complaint filed against the two of them by a kind of a good government group, I think it is.
Not only that, but there's a couple of investigations
Right.
ongoing. One
Yeah.
by the state senate, and another by the board of commissioners in Atlanta, who approve Fani's money
Right.
and
So
supposed
she's
to
going to get a dose of the lawfare herself now.
exactly. Yeah,
Yeah.
she should have uh, accepted her fate and gotten out of this case before this turned into a real mess. Uh, but the judge is going to decide it in 2 weeks. Uh, he could easily kick them off the case, in which case I think her office is kicked off as well. And Georgia apparently has a board of some kind that takes cases where DAs are conflicted and finds somebody to evaluate it and then
Anybody,
take it over.
somebody,
Yeah,
anybody.
right. And that somebody's going to have to be going to have to take it from the ground up. He's got to decide whether it's properly charged. He's got to decide whether the evidence supports all the charges. Whether it these are, you know, this case just went too far off the rails and needs to be either dismissed and recharged or dismissed and forgotten about.
Right. Okay, so do either of you know where the removal cases sit? The 11th Circuit ruled. Is
Yeah.
there going to be a cert petition on those?
Uh, it ruled on Meadows.
Right,
We hadn't heard anything on the Clark
right,
petition. Clark filed an appeal, and at the same time, he asked for an en banc consideration because Meadows had asked for it. Uh,
right.
Meadows had lost in the three-judge panel on the 11th Circuit asked for en banc review. That was denied, and the denial said not a single judge on the circuit voted to review it. So he's done. He can file for cert. But in the meantime, Jeff Clark, who we all agreed had by far the strongest case for removal, his hasn't been acted on by the 11th Circuit.
Okay. So Mr. Meadows is going to have 90 days from the date that the 11th Circuit denied the en banc review. So whatever that day is, he's going to have 90 days to seek a cert petition in the U.S. Supreme Court. And Meadows is represented by Terwilliger, who's a very good lawyer. And so I expect that he probably is going to file for cert, and the deadline just isn't yet. But maybe he'll waive. But if I were him, I think I would go for it. Why not? There's some problems with that situation in the 11th Circuit, right, Chip, where they have a sort of a strange interpretation of the removal statute. Chip, are you still there?
Yeah. Honestly, I've looked at it in weeks, so I couldn't repeat it off the top of my head now. But there was some attention brought to particular phrasing that seemed to categorically rule out a former official as being
Right.
able to assert removal. That the only person that could assert removal would be somebody that's currently a government official. It seems to me that sort of the policy underlying the removal provision kind of gets flushed down the toilet with that,
Right.
because you just wait for the person to be out of office and then you don't
Right.
have the barrier.
Right.
So
I thought that increased the chances that the Supremes would be interested in it.
But
So
I thought it increased the chances that the entire circuit would look at it, because there were two sections, an A and a B. And Ship is right that the A was kind of ambiguous as to whether it applied to only current officers and not former and current. But B was specific as to only applying to one or the other. So they've read the two sections together and said, well, that means since A didn't have the specific carve out for former officers that B does, that means it's not included. Therefore, you don't get to remove if you're removing under A and you're a former officer. The problem was A and B weren't passed at the same time by Congress.
okay.
They were passed years apart from each other and only put together as A and B in codifying the law.
Like a recodification scheme.
Yes.
Okay.
Yeah.
Oh, all
So
right.
Congress wasn't thinking that way when they were originally passed, because they couldn't. They weren't passed by the same Congress at the same time.
I see. Okay. Well, what I'll do is I will check what the deadline is on that and keep track of it so we can tell people it, because that case, if they petition for cert kind of on the normal schedule, I don't think the Supremes, even if they do take it, will be hearing that until next year. Yeah. Okay. So then that leads me to the last question, which is the timing on, hey, Ship, can you put your
yep,
mute on?
yep.
Is the timing on and I'm going to raise this again because Ship wasn't with us before, but is the timing on, could there be a trial in DC before the election? Because Ship, I think you're the most versed as to what's going on between the two cases and with the special prosecutor's office. So let's assume for the purposes of this discussion that the Supremes say the president does have immunity for official acts, but not for non-official acts. And so the case has to go back to Judge Chutkan to figure out which is which and if Smith wants to try to go forward on the non-immune conduct.
Here's what I think she's going to do. She
And
has
by
said that
she, you mean Judge Chutkan.
the judge, she has ruled already that there's going to be 88 days minimum before a trial date, before the reset trial date, because there was 88 days remaining before the March 4th trial date when the case was stayed. And she said she will not give Trump less than the time he had remaining before the March 4th trial date. So if, well, just to make the math simple, let's say that as of July 1, she's got the mandate back. I think she's going to immediately set 88 days is roughly 3 months. So that's all of July, all of August, and all of September. I think she's immediately going to set a first day of October trial date. And then whatever the court tells her she has to do, and whatever is remaining to be done, she's going to jam it into those 88 days, one way or another. She's going to give them short briefing schedules. She's going to decide as quickly as she can, and she is going to try to maintain that schedule for that early October trial date.
Okay. And then with the, well, I mean, if it goes back for fact findings and more adjudication on what's immune and what's not, then Trump can appeal that again, probably. So that might,
Probably.
yeah,
We're in uncharted water. You know,
right.
what if she says no, she's not going to certify it for a locatory appeal, and he takes it
Well,
anyway?
no, on the immunity question, if he still has the argument that he's immune, even though she's telling him that she thinks he's not, I think he'll be able to appeal that. But setting that
Possibly,
aside,
yeah.
yeah,
Okay,
setting that aside, what's going on though with the interplay between her case and Judge Cannon's case, and well, the Georgia case is not going to trial
well,
anytime soon,
let me
right?
go back. Let me go back to just her case real quick, and then we'll go to the Florida case and how that
Yeah,
becomes a
affects the
barrier.
schedule. Yeah,
So the first day of trial, she has already said is going to be the first day of jury selection.
right.
So let's say it's October 1st. That's jury selection. The jury selection in this case is going to be ridiculous.
Right, it is.
You're going to have a probably 200 question questionnaire that's going to go out to probably at least 500 jurors, and you're going to have to sort through those questionnaires when you get them back, and then you're going to have to start bringing in the way we did it in the Oathkeeper case. We brought in 10 jurors every hour and a half. So there were every 90 minutes we brought in 10 new jurors. We did 2 sessions in the morning, 2 sessions in the afternoon. That's only 40 jurors a day.
How long was the jury selection in that Oathkeeper sedition case that you did? How long was it?
4.5 days. So now
Okay.
imagine how long a Trump jury selection is going to take. Imagine how many jurors are going to get screened out right at the start from the questionnaires. So I think the jury selection is going to take at least 2 weeks, if not 3 weeks.
Okay.
Now you're
Now you're at the
October.
end of October.
Now you're at the
Yeah.
end of October, and you haven't even given opening statements yet.
Ship, question.
Yeah.
How in the world do you find an unbiased juror that close to the election? Everybody's made
Right. Yeah.
most of the people by then have made up their mind who they're going to vote for, and it doesn't take a genius to figure out if we can put one of the candidate my guy is opposed to in jail.
Boy, my guy's road to the office looks really
Right?
smooth.
Yeah. How do you pick a? How
Well,
do you
let
find
me
a?
ask you this. Let me ask you this. Do you think there's any way around the idea that asking the jurors who they voted for in 2020 isn't a relevant question? It goes to bias.
I think it absolutely is. I think it's a relevant question. Who
And
have they
no
voted?
judge is going to want to do that, though.
Are
Too
My
bad.
are
It
they
goes
God.
to
going to
bias. You're
are
trying
they
to
I
going to vote?
protect
know.
bias.
I
I
know.
think
But can
I
you
think the question.
imagine being the judge approving that question? My God.
How about the question? Do you intend to, or have you voted in this election?
Yeah, what if she
Already.
crosses over into the voting period?
Yeah.
That's insane.
Yeah. Exactly. If you got early voting, if you already cast a ballot, then who did you cast it for?
Well, even if you plan to vote, if you plan to vote, that means you are likely to have made a decision. You likely have chosen a horse to ride on to victory. You're biased.
Now, what I think she will do
Oh, they'll
what I think
all
she's
say that
inclined to
they
do.
totally can be
Oh yeah,
unbiased.
no, no. I think what she will do is, actually, I've never even had a case before, so I'm opining about something I have no basis to opine about. But it strikes me that the route that might be the easiest is for her to kind of put on a very narrow set of blinders and say, I'm going to ask the same questions I ask every jury, and that's it.
Well, I don't think you can do that, but I do think the problem is that when you're doing jury selection in federal court, there's enormous discretion for the judge to decide what to ask, and B, the question is, can you be a fair juror? So judge can say quite properly under the law, I don't care who you voted for. I don't care who you like politically. The issue is, can you be fair? So, and I appeared in front of judges that would browbeat jurors into saying they
Yeah,
can be fair,
absolutely. Yeah.
notwithstanding they came up to say, I'm a little bit queasy about this. So as long as the juror, doesn't matter who they voted for, if they voted just yesterday, as long as they say, oh, but I could be fair, the judge can say, fine, you're on.
Right. That's what will happen. Although that's not at all acceptable. you
No,
know.
I have raised this issue in DC cases, and I also raised it very vehemently in a Hawaii case that was very high profile. And I said to the judge, I said, this idea that if we ask a juror, can you set aside all your opinions and judge the case based only on the evidence? That's a legal fiction. There's no truth to the answer that comes back. But we
Right.
accept it as true because that's the only way the process works. And the judge agreed. He said, yes, it is legal fiction, and it's the way we make the process work. I said, well, I'm sure the defendants rest comfortably at night knowing that.
Yes. Right. Exactly. Yeah. So, all right. But then let's get to the question of can Judge Chutkan set an October 1 date, even if she wants to, in light of Judge Cannon's case in Florida, or not at this point?
Well, I expect it. So the dueling dates came out for Judge Cannon's case in Florida Thursday, right after her hearing, and she asked the parties to submit their proposed trial dates. And Jack Smith wants July 8th. And the reason he wants July 8th is that's as close to the Fisher decision as he can get, really. And so he
Right.
wants the Florida case started and ended in time for the DC case to start in, late September or early October. He wants the Florida case over with. So the earlier the Florida case starts, the earlier it ends, because he's got a risk of losing that case or if we're on a hung jury in, the Fort Pierce courthouse, which has 4 counties that voted for Trump. He doesn't have the juror pool in Florida that he has in DC. So he's at risk there for a possible jury nullification, hung jury kind of situation, and not getting a definitive outcome. So he wants that over as quickly as possible, and then he's going to, because if it's got to be over by September 1st to be able to roll into the DC case. So that's the date he wanted. The Trump people came back and said, well, we don't think it should be before the election for those reasons. But
Right.
the earliest that works for us, I think they said was August 10th, or I can't remember the 2 dates. They gave 2 dates in August. But
Okay.
what everybody ignored was Stanley Woodward, a friend of mine, represents the co-defendant. He said, I'm unavailable from August 3rd to August 25th.
Aha.
Wait, he's as we lawyers all know, lawyer availability is something that influences the selection of trial dates. I'm not exact. I think I know what his unavailability is, but judges don't typically just say, "Well, I don't care if you're unavailable. You'll be here.
Right.
You're in
So
contempt."
sucks to be you. You have to be here anyway. They don't usually
Yeah,
say that.
but they don't usually say that because what he said is the first week of September. Well,
Right.
does the first week of September work for everybody? Nobody's conflicted. Why is the first week of September work? What is Jack Smith going to say? No, I can't get my DC case in if we start the first week of
Right.
September.
Cannon's not going to care about that. Well, and then
Exactly.
there's the other issue that I don't see too many people talking about this. Okay, say the Supremes say that the president is immune for official acts. If I'm Trump's lawyers, I'm going to be reading that Florida indictment to see is there anything in there at all that's alleged while he was president, actions that he took while he was president, and
They've
say that.
they've already filed a motion on that.
Yeah.
They as to the first 31 counts, I think they say they should be dismissed on the grounds of immunity because all of them are based on Trump causing the classified documents to be boxed up and shipped to Mar-a-Lago
while he was
while he was
president.
president.
Right, exactly. So, they're going to be saying if the Supreme Court immunity case comes out a certain way, they're going to be telling Judge Cannon she needs to dismiss that case too, right?
Right. The other thing, but you know what they might do first there? And I only saw on Twitter that this has been filed, so that's obviously not a completely reputable source. But does anybody know? Oh, it's not disreputable, but you don't know what the people who posted know.
Yeah, right.
Has anybody else seen that they filed a motion to disqualify Smith on the Ed Meese strategy in Florida,
They
Okay.
saying
did.
that they
They did.
Did they do that in Florida? Okay,
They
because one of
they
our
they used
questions, yeah,
they
one of
used the
our
Meese.
yes, the Meese brief. One of the questions we got, you guys, was on that, which is because the Supremes had asked for the briefing on that back in December, right?
no, they
Um,
didn't ask for it. That just got filed as an amicus brief. They did not ask for it, and they did not
oh,
ask for it, and they did not. It's not mentioned in the cert petition.
And the D.C. Circuit put it in a footnote that
right.
they are aware that it was raised in an issue, but since it was not raised in the trial court or on appeal, they don't think they have jurisdiction to decide.
Okay,
Right.
well, so this question was, since it was asked for, okay, which I was like, okay, I don't know about that, but that was the question, is since it was asked for, why aren't the Supremes asking for it now? That for that issue to be addressed. But I mean, those folks can do whatever they want, but I don't see the courts touching that with a 10-foot pole. Do you?
Why wouldn't Cannon? If Cannon thinks that he's improperly exercising the authority of the United States, she could dismiss the case on its jurisdictional issue.
Right.
If he's not a proper officer to serve in the prosecutorial role, the case is not properly in the court.
Right, and I agree with that based on the recent Supreme Court opinions, Lucia and otherwise. So, and you're right, I wasn't thinking about Judge Cannon. I don't see the Supremes touching that, but you're right, Cannon might take a flyer on that.
No,
Exactly.
yeah, I don't think the Supremes will, but that may be the first motion Cannon takes up.
Yeah, and now because it's jurisdictional, even if she denies it, it's jurisdictional. I think that is subject to interlocutory appeal.
Maybe, right. There's no clear law on that, but it could be. Yeah, there's no clear law on that on this criminal side, is unfortunately the reality. Because how often do you get a jurisdictional, question in a criminal case? Not very often. So yeah, okay. So timing wise, just I still am of the view that Jack Smith's case here in D.C. just cannot happen before the election.
The mechanics, just the mechanics of having that particular jury trial that won't begin earlier than October 1st, just is not going to happen.
Yeah. Chip, King, you agree or?
Well, Judge Chutkan could try to jam it through, but she's going to have to do some mighty creative jury questionnaires and limiting questionnaires and put mighty big blinders on because I don't think it's possible to
Yeah, but
get.
I mean, it might start, but how much of it might actually start? And
Well,
doing it
that
that
this
way,
that also assumes that it's not up on appeal again.
Yeah.
right? And doing and the way the politics of it seems to be played out, doing it that way only exponentially ratchets up the whole lawfare claim.
Right.
If they could have done it and ended it 4 months before the election, that's different.
Right.
To jam it forward when it can't even end, and the only thing you really accomplish is to keep Trump sitting in a chair in a courtroom. That plays into all the worst assumptions that people have about why it's being done.
Right. And so folks understand that the law as it currently is that if you're on trial, you must be present in the courtroom for your trial unless your presence is waived, and that almost never happens in federal court on felonies. I mean, I don't know of any case where it has happened.
There was an article written yesterday by this. It's a Politico writer, but he's a lawyer. I think he was a former prosecutor for a short period of time in D.C. And he wrote this article yesterday that proposed, well, here's what she could do. She could have trial like 3 days a week and give
Yes.
Trump 2 days to
Steve was talking
campaign.
about this before you joined.
Oh,
Yeah,
okay.
we were laughing at it. Yeah. Oh God. This is
Where was he a prosecutor? In the Eastern District of Mongolia?
yeah.
No, I think in D.C. I looked up his
Oh my.
bio.
Oh my. I'll have to look that up because that's just crazy. You can't conduct a jury trial like
Well, let
that.
me ask you, Steve. Let me ask you, Steve. In your experience, what's the profile of a guy who's an AUSA for 4 years and then becomes a writer for a magazine, for an online magazine? Maybe he
I,
wasn't very good at his job.
Maybe the office wasn't for him or the courtroom either.
well, the one exception I know to that, and it's a sterling one, is Scott Turow, who is a fabulous author
Oh yeah.
and by all accounts is an excellent lawyer too. But other than that, I'm with you.
But what about? I thought Jeffrey Tubin was a spectacular member of Lawrence Walsh's team.
I must have missed that part.
Well, you don't know that. A lot of people don't know this.
Oh my.
Jeffrey Tubin was like the most junior member of Lawrence Walsh's Iran-Contra staff.
Oh my
And then
goodness.
he left, took all of his notes with him, and wrote a book.
Right.
And that made him famous. Was writing the book on Iran-Contra after he basically was a coffee boy for 2 years.
Oh, well, he's special. I'll say that for him. So, okay. Well, I think that that's the end of my list of things to talk about tonight. You guys got anything else before we sign off?
No, I'm sorry to get here late.
That's all right.
No, but I'm sure something will happen in a week or so.
Oh, well, it's going to start happening tomorrow.
Yeah.
All right. So, we could maybe, if that Colorado case comes out, we could maybe get together tomorrow. We'll see what time it comes out. Well, it'll be in the morning. So,
Did you see Norm Eisen's?
yes, I did. I commented on it. Yeah. Oh my.
I think that this has been speculated about. I think there's even some substance to it. Somebody reported on it with some substance, but he has apparently been working with Fani Willis's office
Right.
for months and months to help them put that thing together because obviously we can see there's not a lot of talent in the office to
Yeah.
do what they did.
Now I've seen that allegation, but I haven't seen any actual facts to that effect.
Well,
So,
it's kind of like working through Brookings. It's like it's like an
ah,
informal fellowship kind of
I
thing
see.
with somebody who's being paid by Brookings. Not that he's actually formally a part of the team. He's not.
Right.
He's kibitzing. He's communicating by email and sending them drafts and stuff like that.
Yeah. Okay. All right. Well, I do find it astonishing that the left, the lawyers on the left, have basically said things that I just think that is 100% not what is going to happen. Like that the Supremes would not take this immunity case. I thought it was completely obvious that they would. And then that professor from UT the other day, Ship, who was arguing with me about, well, he was asserting that the there's no, serious lawyer who thinks that the Supremes are going to say the president has immunity. And I'm like, I don't know. How
Yeah, you know
are
what?
you arriving at this miraculous conclusion? I'm
I'm
not
kind of
even
mixed on
saying
that
that they
guy.
definitely will. They certainly could rule that it's qualified immunity versus absolute, right? So I don't expect them to do that, but I'm not staking out the position that there's no possibility of that. Whereas these lawyers on the left, they take these extreme positions.
Yeah, that guy's kind of interesting. I did kind of snipe at him a little bit before I really knew who he was,
Right,
and we were on opposite sides of the removal argument, and then
right,
they end up. The outcome is this, favored his position, but it was for a reason that he never suggested and I never suggested, which is this odd language in the two provisions of the statute.
right,
Nobody ever focused on that.
right.
But when I looked into the guy, here's what I'm going to say about it. he's got a pretty significant bio and background doing capital cases on appeal. He's
Right.
done a lot. He's done a lot of that in Texas and elsewhere, where he comes in on appeal for capital cases and just does all of the appellate litigation up to the Supreme
Right.
Court. So he's a serious lawyer. He's not a
Yes, of
guy
course
that's
he
just
is.
he's
Right.
not a
I can see that. He's a serious lawyer, but to say, well, just these extreme positions, it just looks like his politics is getting in the way.
yeah. But I
Well,
don't have a
then,
lot of I don't have a lot of respect for the other guy, Vladek or whatever his name is.
yeah, Steve Bladdock.
He's just
Yeah.
a law professor who's never accomplished anything other than write a law book.
Right. No, I have a similar view of him. He seems like a nice guy, but it's like, I don't know how you're arriving at these unbelievable conclusions.
Yeah.
And then there's the other one. What is his name? Phil something, who is saying, oh, there's no way they're going to disqualify Fanny. I'm like, no way? You don't see any basis for
I
this?
keep seeing I keep seeing people
What?
talk about, well, it's Fulton County politics. You guys just don't know how it works down here. But this is it was, without having too much of a blind spot for this. I keep being drawn back to the point that McAfee, that's the name of the judge, right? McAfee. For
Yes.
good or and this isn't a crowning achievement of everybody that's ever done it. He was an AUSA for 5 years.
Right.
The level of lawyering that he, I think, would expect is different than what he's seeing. Yeah,
Yeah.
he's been a state court judge, but he's got to look at that and say, and some of these people are all friends. They
Yeah.
were all judge
They all know each
colleagues.
other. Yeah.
Right,
Right.
right. They're all friendly. He gave money to her for her campaign, blah blah blah. But at some point, he's got to say. I think I said this in a couple of spaces ago. The reputation of the Fulton County judiciary is sort of on the line here.
Right. If
And
he
if he signs off on this and gives a pass, they're just a laughing stock.
Right. Okay. So here he is. This guy's name is Ron Filipkowski, and he says
Oh,
he's
that
a
guy.
former federal and state
He's a joke.
prosecutor.
He's a joke. He is just an online provocateur. That he is as he just lives on Twitter to basically agitate.
Okay.
Not somebody to be taken seriously.
Oh,
He's a big
okay.
anti. He's in Florida. He's a big
Yeah.
anti DeSantis guy. He's an
Okay.
anti-Trump guy. He
Right.
claims he's a former member of the GOP, but
Yeah.
saw the light and became a Democrat. And it's like, you guys, I don't take him seriously.
Right. Because I think, okay, there's a few times where I'm willing to say this for sure is not going to happen, and here's why. Right. But most of the time, I feel like what we're trying to do is say, okay, well, there's arguments on both sides, and you can't say what's going to happen. Or there's arguments on both sides, but it's more likely that the judges will see it this way, right? And sometimes we're wrong because you can't be 100% right when you're a lawyer. You can't really, really always predict what a court is going to do. So the absolute positive, certainty that these people have that the judges are going to rule against Trump just astonishes me. It's like
Yeah,
that's the
yeah.
way
As
they want
somebody
it to
said,
be, so therefore that's what's definitely going to
I,
happen.
I was
What?
listening to a panel discussion about the Trump case, and somebody said, the issues here are more serious than the liberals give it credit, because the
Absolutely.
liberals, they filter everything through Trump. If
Right.
you took Trump's name out of it and you put Bill Clinton's name in, or you put Dwight Eisenhower's name in, or you put Franklin Delano Roosevelt's name in, and it's not Trump anymore, you take
Right.
the arguments much more seriously.
Right. I know. And that's what I'm saying. It's just astonishing to me. It's so absolute because they just they want somebody to come along and take this guy out so they don't have to deal with him anymore.
Right.
It's
They're
horrifying.
terrified of what he's, and then there was a comment today that was really interesting, is that, once Trump becomes the presumptive nominee, by tradition, he is entitled to begin receiving intelligence briefings.
Right, I know. I know. Right, I know. I mean, oh, these people are going to lose their minds.
Yeah.
So, well, I have a quasi prediction. Okay. So I'm wondering if in this immunity case, if it might not be the case that, sort of like the Colorado case, the way the argument went, that the liberal judges are also on board with the president has some immunity, and that it's not as heavy of a lift as the liberals are saying, or as the circuit court made it out to be. I could be wrong about that, but I just can't imagine that they don't read Nixon v. Fitzgerald and say, this is the right answer. Why do we really have to do more than this?
Yeah, my focus on Nixon Fitzgerald has always come back to the point that the district court kind of laughed off the immunity claim.
Right.
The appellate court wasn't even going to take it up because it didn't
Right.
think it had jurisdiction as an interlocutory issue. It was not
Right.
even going to consider it. And then the Supreme Court reached out and grabbed it on the cert for judgment, and then found, oh my God, he has immunity. Everybody had laughed it off and wouldn't take it seriously until the Supreme Court says, no, we actually think there's a reason here. So you have the same kind of attitude from the district court, which just says, no circumstances ever. The appellate court comes right along and says, well, of course, no immunity ever. And then the Supreme Court's left to come along saying, maybe we ought to think about this a little more because it doesn't seem like anybody else really has at this point.
Right. Exactly. Okay. Well, I just have this sort of idea in my mind that we may end up getting from the left the same reactions that they showed during the Colorado argument. They were losing their minds over the fact that the liberal judges were seemingly on board with the fact that Colorado shouldn't have done that.
Right.
And
So,
I'm going to be contrarian. I don't think all justices will have an easy time of finding some immunity. That I think there will be some on that court who may concede immunity in narrow circumstances, but we need to carefully craft it so that it doesn't allow uh, the kind of hypotheticals, the SEALs Team 6
oh my
hypothetical.
God.
That so we need to put guardrails around whatever immunity we come up with. I think that it's not. I don't think it's going to be a slam dunk complete immunity case. I think you may have more than one opinion going different directions.
Okay.
I actually think so. I agree. I think there are going to be multiple opinions. I think they're going to be hard to decipher. I think ultimately, though, it's going to get sent back for more work to be done in the district court with the expectation that maybe one of two things happen that make it all go away. Trump wins, in which case
The election, you
case
mean?
gets Trump wins the election, in which case the case gets dismissed, and the issue of the scope of the immunity never has to be resolved. Alternatively, Biden wins the election, and then saner heads prevail and say, okay, Trump wasn't reelected. He'll never be reelected. He'll never be president. So Biden should just pardon him and put all of this to rest.
Well, I don't know what the chances of that are. I can't see the Biden people being able to hold their nose and do that.
But he's not risk to. He's not a threat to him anymore. He's now yesterday's news as a
Yeah, but they
political
want him
force.
punished. They
I'm
want him
not
punished.
sure. Yeah, but then what I'm saying is cooler heads prevail and say, guys, let's put that chapter away and move on to the policy that we have in mind.
Well, I don't know who those cooler heads would be over there,
I,
but
I I disagree. I think the plan all along has been to crush Trump and all of his followers, and you don't do that by pardoning the head.
You know
You've
what
got
though? You don't do it by putting him in
by
prison
giving a
either.
pardon to the head of the snake. You got to kill all of it.
well, that does put Biden, if he is reelected, in the position that kings have always been in, which is, do you martyr your opponent or don't you?
Yeah, so I think they claim the mantle of being the unifying force if they do that.
Right.
I'm talking about fomenting protests where you can go
It'll
arrest more protesters.
it'll
And
be worse if they put him in prison.
I know
Um,
that's what I'm
yeah,
saying. I think
yeah,
that will be a win to certain people.
yeah.
That's a design is not stop with Trump.
Right. I'm worried about that too. But we will see. Um, so starting tomorrow, we're going to start to get answers on some of these things. Colorado case, I think, is coming out tomorrow. So we will regather to discuss that, I'm sure, at some point, whether it's tomorrow or the next sometime later this week. We'll see. And that's all I have for tonight. So I'm going to sign off.
All right, take care, everybody.
Okay. Good night. Thanks,
Good,
everybody.
good night.